Supplementary list. Supplementary list item number 80. Matter fixed for 10.
Mr.
Nair is there online.
Yes.
Yes, Professor Sukumar is also there.
All right.
And all the JTF members.
All right. You begin, Mr. Monty. You tell us.
Yes, my lord. We have filed an affidavit. The hard copy is before your lordship. That is affidavit dated 17th January 2023. The summary of the affidavit is that, as per the direction of this Honorable Court, the Comprehensive Action Plan (CAP), I have given the draft copy, executive summary of that. That is by annexure W/1. And if your lordship will see page 13 of my affidavit, page 13, last paragraph. The document titled Comprehensive Action Plan for Conservation of Elephants and Mitigation of Human-Elephant Conflict in Orissa, Executive Summary and Action Points is annexed herewith as annexure W/1. The detailed text elaborating the points mentioned thereof, including maps for the Comprehensive Action Plan, is under preparation and will be submitted within a month before this Honorable Court for kind appraisal and further directions. And we have submitted time-bound programs. Within this much of days, we will finalize this within this month. So within 1 month, Mr. Nair can explain better. Yes. And within 1 month, we will complete this plan and submit it before this Honorable Court.
Yes.
Mr. Nair is.
Yes, Mr. Nair.
Sir, namaste and good morning, sir.
Yes.
Sir, it's actually almost last about 45 odd days, sir. We have been very intensively working on framing this particular comprehensive action plan.
Okay.
A series of consultations have been done, including all circles. We have consulted your lordship, a variety of experts, including those whom you had kindly directed us to consult, including Dr. Bishwajit Mahanti, Shubhendu Malik, whole range of local NGOs, activists, etc. So as sum and substance of which, sir, is that we have formulated a very action-oriented, practical sort of an action plan, also taking into account the cardinal principles, sir, enshrined in the 3 documents which Dr. Sukumar has mentioned in his PowerPoint presentation, sir, which was taken on record by this Honorable Court. That is the Karnataka Elephant Task Force report, and the North Central Elephant Task Force report, which is submitted as a draft to Project Elephant, and also the 2018 Carrying Capacity Report of Orissa, sir. We have been constantly guided by Dr. Sukumar in this, and we've been lucky to get his constant guidance. So, sir, what the crux of the matter, sir, is that we have envisaged a long-term action plan wherein we hope to maintain a viable population of about 1,700 to 1,800 elephants in Orissa, sir, which is the indicative number which was clearly brought out by the 2018 Carrying Capacity Report conducted by Dr. Sukumar and his team. It's a very extensive and a very valuable study, sir.
Right.
Accordingly, we have formulated a zone-based approach where we have divided Orissa into 4 zones, Your Lordship.
Yes.
Which primarily encompasses Zone 1, which would be the Elephant Conservation Zone, which is existing 3 elephant reserves. That is Mayurbhanj Elephant Reserve, Sambalpur Elephant Reserve, and Mahanadi Elephant Reserve. Zone 2, what we call a coexistence zone, wherein there are large intact reserve forest patches having adequate elephant habitats, where human presence is not so significant, and which has a long-term potential for elephant conservation in Orissa, Your Lordship. Zone 3 is what we call a conflict mitigation zone. And this is a zone where we need to pay a lot of attention. We have several scattered population of elephants in this zone, but we do have patches having good to moderate to degraded forest areas. So we require very intensive short-term target-oriented approaches to maintain some of these populations, but we might have to translocate a few individuals to either Zone 2 or Zone 1, as the case may be, once we start looking at it in finer detail. And Zone 4, Your Lordship, is what we term the elephants removal zone or the exclusion zone, These are largely would be treated as no-go areas for elephants because it's heavily, densely populated, human-dominated areas where there is hardly any elephant habitat left, Your Lordship. Like such as the recent case of incursion of an elephant into Puri, where it had to be tranquilized and removed forthwith back to our rescue center. So,
where does Anugul figure in all of this?
Sir, Anugul, basically, we will have, if you look at we have given the ranges in the action plan, page number 8, Your Lordship. So if you look at it, we have looked at circles and divisions. So Anugul circle, we already have.
Oh, it's part of the Mahanadi Elephant Reserve.
It is a large part of it is part of the Mahanadi Elephant Reserve.
All right. Because that is where I think there was a incident of 4 people getting killed.
That is right. That is right, Your Honor. After that, also, if you look at zone 2, that is what we call the coexistence zone also. Angul circle figures and Angul division figures, and particularly one range called Chendipada. So we have, so that there also, there is conflict, but we have to look at it on a targeted basis, sir. So within about almost about a space of this very short span, we have tried to the extent possible to look at all the existing guiding documents. We have constituted circle level committees looking to site specific details. But nevertheless, sir, there are a few ranges which might fall in 1 or 2, or part of the sections of which might fall in 1 or 2. This requires a little bit of fine tuning and detailing, sir. And because any sort of elephant movement study would require at least a year, sir, in terms of wet season and dry season, as Dr. Sukumar had explained the other day. I think we will, with your kind guidance, we might be able to, in principle, take this approach forward, subject to a little bit of fine tuning, which will come after this year-long corridor study, Your Lordship. If that is one gray area which needs to be ironed out, and any National Institute of Repute could be roped in, we would commission at least a 1-year study. They would be able to give us clear-cut indication of what are the status of corridors and how much of it is functional and viable. And that also could be plugged into this. But nevertheless, Your Honor, this contains a fairly comprehensive look at all the possible action points divided into what we call a 10-pillar strategy, Your Lordship. So in 10 verticals, we have looked at clear-cut action points, divided them into short-term, medium-term, and long-term measures. Short-term being defined as anywhere the measures which would start immediately to within a year. Medium term would be 1 to 5 years, and long term, anything beyond that, which can go up to even 20 years, Your Honor. Right. So most important of which would be the habitat management interventions, because we have to do it on a targeted basis, identified locations. If we do it in the longer run, year after year, we should be able to reclaim a large amount of degraded areas, which can be developed into elephant habitats. So it is quite fine-grained, Your Honor, within the available short time span. We have tried our very best to put these things.
If I might just ask, I mean, could be a random question. You know, yes, the recent incident of one of the elephants getting electrocuted. I think that was in Nayagarh, or I don't know which district that was. Was it Nayagarh? A female elephant got electrocuted just 3-4 days ago.
Yeah, we have actually. That's when in Attagad, Your Honor. We have got one in Attagad, yes. We have got all the three recent elephant cases have been that of electrocutions.
So how is this electrocution death? What is the action plan for that, and whom are you involving in that?
Your Honor, I'll just take a couple of minutes to just apprise you of the matter.
Yes.
Ever since JTF has started functioning, we ensure that we send our members to the spot of elephant carcass detection, Your Honor. And what that has resulted in, which is again an insight for us too, is that majority of the elephant deaths happening right now can be ascribed to electrocution. That has emerged as the preeminent threat and a very, very pervasive threat, Your Honor, and possibly one of the most difficult to deal with. So we have actually, if you look at page number, just a second, Your Honor, I'll just tell you. We have given us, we have treated it specifically, trying to look at electrocution. Just a second, Your Honor, I'll just telling you. Special focus. Yeah, it's page number 21, Your Honor. We have given a special look at preventing accidental and deliberate electrocution deaths of elephants.
I think
Your
bottom
Honor,
page.
with your permission, I would really like to flag this issue in the sense that we have had close coordination with the discoms, that is the distribution companies. And because, I mean, their point of view is that because of this massive penetration, because of electrification schemes that has taken place recently, a lot of interface, Your Honor, which has been Odisha elephant habitats anyway is very interspersed and very diffused. Added to that, once the deep penetration happens, the interface areas have become very high, Your Honor. But I really would flag the point that the discoms also should up the ante, so to say. We have joint patrolling in place and so on, Your Honor. So one thing that could possibly be done is to have, apart from all the regular coordination meetings at all levels, etc., which is taking place, maybe, Your Honor, one concrete step would be to increase the number of linemen from the level of the discoms, actually, because as of now, what we understand, some of them are dealing with very large areas. So vigilance from there and also would be of real significance, Your Honor.
No. So what happens? The villagers actually tap into the lines and draw from that and electrocute the fences, or they apply and get it electrocuted?
Your Honor, I'll just take a minute. How it happens, Your Honor, is that it happens due to a process called hooking, illegal hooking. So what
That's right.
What they do, Your Honor, wherever there are bare conductors, in common parlance, wherever there are electric lines passing through forested areas, it could be a low tension line which supplies to a household. In very rare cases, it could be a 11 kV line. So what they do, they put these hooks onto the conductor, tap the electricity, and then what they do, they will spread it around a field using stakes. They'll have bamboo stakes placed on the ground, and they will put these strands. Sometimes what they do on existing power fences, solar power fences, which are not designed to kill elephants because they'll only give a pulse, they will charge it using a live electric wire, just connected onto it. So which means it becomes a death trap. Third thing, and most of the times, Your Honor, it happens due to, when you look at it in detail, the patterns, most of it happens due to two reasons. The majority of the reason what we have found is that in forested areas, they put it for preventing depredation of wild pigs or wild boars, which cause a significantly large amount of crop damage. So to prevent that, they do it. In a few cases, it has also come to our notice that they also do it for what is called bushmeat hunting, Your Honor. What they do is that for getting bushmeat, they'll put it for whatever animal they come across. They don't do it deliberately for elephants. We've not come across any instance where they really want to kill elephants. At least our social carrying capacity is below that right now. But due to these two reasons, elephants, because they're moving far and wide, and particularly the subadult male elephants, which have a propensity to range far, they come into contact. And most of the times when we examine the carcass, we have found that the point of contact is either the trunk, down below the trunk on the dorsal or the ventral aspect, or on the foot. And in very rare cases where elephants have stumbled into unprotected transformers, Your Honor, it has been on the head or on the sides.
Okay.
So this is how the electrocution.
You mean the electrocution death can happen also because of a transformer?
Yes, Your Honor. Wherever there are.
Obviously, the transformer is an unprotected.
Yes, Your Honor. There are small transformers which are kept to sort of step down power sources to give it to, let us say.
So, but the discoms, did you speak to the discoms when you drew up this, or?
We did, Your Honor. We had coordination meetings also. A couple of, just during the process also. We did do that. So we also have, Your Honor, a large number of steps, including cabling, using ABS, what is called aerial bunched cables, primarily meaning that all these bare conductors are insulated. So efforts are going on. A fairly large amount of work has already been done. But regardless of that, Your Honor, we need to have certain close interventions by the discoms. And also,
from the people's point of view, what alternatives do they have? Because they're resorting to this to keep away the boars and all of that. So what are the alternatives for people to protect their own crops and villages and all of that?
Your Honor, one possible alternative would be a very, very recent, careful, and the deployment of solar fences. Your Honor, we could give them subsidies. I mean, instead of them having to actually tap a live wire and put live protective barriers, we could actually use a proper solar fencing and various models of it. So, a recent scheme called Jeevan Rakhya Surakhya, which you have just launched, wherein it's a subsidized model of giving opportunity for local people to participate in this solar fencing program, has just been rolled out. At Henkanal, it's been piloted. All the other DFOs are already talking to people to roll it out. This could be one of the major steps, Your Honor.
No. What happens if the elephant comes into contact with a solar-powered fence? It won't get affected?
No, it will not get affected, Your Honor. What it does is it gives a very pulsating electric current. It doesn't get electrocuted actually.
I see.
It's a pulsating current which doesn't cause mortality. It just gives it a momentary shock, which is enough for it to get repelled. And elephants and other animals also elephants more so, sir.
The local administration in these areas should take the effort of contacting the villages and people.
Yes.
Dissuade them from having electric fences and offering to replace it with solar fences, correct?
That's correct, Your Honor.
I think the local administration will have to get active on this.
Yes.
Your Honor, I would take the liberty, Your Honor, where we talk about interdepartmental coordination. And point number 1 is that we have recommended for the constitutional what is called a district level human wildlife conflict mitigation committee.
Right.
Under the chairmanship of the collector. So ultimately, these issues, of course, the DFO will play a cardinal role in flagging the issues. But if a committee is formed at the level of the district administration itself, at apex level of the district administration, these should be given more importance and more focus can be given to these measures, basically. The only caveat, Your Honor, which I would like to mention, and which Dr. Sukumar also had very perspicaciously pointed out, is that while erecting solar fences, it should not in the longer run prove to be counterproductive, in the sense that there are certain movement areas of elephants where they need to actually move through the landscape. So they should not prove a hindrance. And instead of solving the problem, we should not be diverting the issue to another area. It will ultimately be transferring the problem to another area. So very site-specific manner, it has to be carefully thought about and implemented, Your Honor. But it is certainly one of the ways out. And we also have, while during the preparation of the plan, Your Honor, we have also come across a very interesting model of what is called dismantleable portable electric fences, which is going to be effective in Sri Lanka and some parts of South India, wherein the local communities themselves sort of take initiative and then earmark areas where it could be installed and then taken out after the crop season, so that these are not permanent barriers, Your Honor. So we have looked at various models possible, and we think that once these things are rolled out and tried out and tested, we would be having a more fine-grained and a clear-cut approach.
This about these FIRs that have been registered, which pillar deals with that? The follow-up on the criminal cases and
Your Honor, there is one of the thematic pillars that we call is protection, enforcement, and prosecution. That is on page number 24, Your Honor.
Right.
24. If you look at point number, we have actually suggested that, just a second, Your Honor, I'll just come to the part of it, the prosecution part of it. That is in page number 28, Your Honor, and 29 actually, where we say, in page number 29, if Your Honor, if your kind attention is drawn to page number
37.
29 and point number 31. We have clearly mentioned that we've indicated an indicative time span of 60 days for wildlife cases, Your Honor. What we have realized is that 60 days is a reasonable period of time to complete the investigation and submit a final prosecution report. So the JTF, as of now, is tracking almost all the cases, and we are trying to push the submission through and also hand-holding of cases so that quite watertight cases are presented before the court. If Your Honor would like to go a little bit into what the JTF is doing on that count, with Your Honor's permission, I could ask the additional SP JTF to elaborate a little bit about where we stand on that, Your Honor.
Yeah, including that last time's incident in Simlipal,
Yes,
where
Your Honor.
three forest officials have been arrested and all that. Yes.
Mr. Panda, additional SP.
Milord, namaskar. As regards the Simlipal case,
Yes.
we are continuously pursuing the investigation day-to-day basis. In the meantime, we had brought the principal accused on remand. JTF team, along with me, had proceeded to Udala, and where we interrogated that accused, but he did not disclose the names and identities of his associates. Thereafter, he was produced in the court after recovery. Only he gave recovery of a portion of the trunk of the dead elephant, which was seized basing on his statement. Thereafter, we tried to interrogate three forest officials who were by then released on bail, but they did not cooperate. Thereafter, we have intimated Honorable SDM Udala about violation of bail conditions to reject his bail and issue NBW. Those three officials are by now they have not appeared before the IO. IO has been continuously guided about the other portion of the investigation and to trace out the remaining accused persons. In the meantime, we are also coordinating with STF. Since the tiger skin case, the accused was same.
No, 1 minute, sir. Before you leave the Simlipal case, which means 3 of the accused who have got bail have absconded.
Sir, exactly, but they are not appearing in spite of our sincere efforts.
No, what does it mean? I mean, you've said NBW is issued, which means they're out at large.
We have made, the IO has made prayer before the SDM that they are not cooperating with the investigation.
Have these people been suspended, Dr. Nair?
Yes, Your Honor.
Yes.
So why are we not doubling our efforts to, why are you not ensuring their presence now in the criminal investigation? The bail has to be cancelled.
Yes, Your Honor. It has to be cancelled. That I mean, we are moving towards that only.
Sir, we are already on the way of making prayer before the HGM Mudala. HGM Mudala suggested that finally you issue one written notice. May it be fixed in their house or may be received by some of their relatives. In spite of that, they have not appeared, and the IO has been instructed to make a prayer for rejection of their bail and issue of NBW.
That should have happened by now. No application has yet been filed.
Sir, yesterday only I had talked with the IO. He was about to make it in the court, sir.
So no charge sheet has yet been filed?
No, sir. Charge sheet, final prosecution report has not been submitted, sir.
Sir, time is passing by. I don't know.
Sir, we are...
All this action plan that's been drawn up, the testing point is this, sir. This action plan has been drawn up to speed up the whole thing.
Sir, everything...
Dr. Nair, what happens? This action plan, I hope there's no more bureaucratic steps to be taken. It is straight away will be rolled out.
Sir, most of the I mean, if you look at the action points that has been suggested, Your Honor.
No. Action point is one thing. Action plan. This action plan does not need to further get approved or anything, correct?
Your Honor, most of the steps, almost about 60% of the steps are sort of ongoing, which we just need to give reinforced focus, like for instance, the prosecution reports. Now we have given timelines. A few, Your Honor, like for instance, commissioning the corridor study, filling up of vacancies, etc., would require...
No, I'm talking of actually rolling it out. I'm not asking about the implementation yet. That this action plan comes into operation.
Yes, Your Honor. Much of it can directly come into operation.
No. Don't. Now you're getting bureaucratic. Don't say much of it and all that. Will this action plan become operational now?
Yes, Your Honor. We need to actually ask for a few not clarifications exactly. Like, for instance, the high-level committee of the chief secretary that is constituted, district level committee under district collector that has to be constituted. These has to be constituted, Your Honor. That's it.
No, Mr. Mohanty, what will the government straightaway implement this action plan or not?
No, this has to be approved by the high-level committee. And
which high-level committee?
By the chief secretary. Chief secretary is the head of the high level. It will be.
No. When will that happen?
So that is why we have only prayed for 30 days time. Within that period, we will ensure that this action plan is approved and it will be on the public domain.
Why 30 days? Why 30 days for this? This is
Because
already drawn up with such great care and attention.
Yes, my lord.
Why should it get delayed?
Chala.
The elephants are not going to, the problem is not going to end because the action plan is being considered. Every day we are getting more incidents.
Once your lordship sees, once the action plan is approved and it is implemented, then a lot of problems will be.
Which is why delay it? What I'm saying is why 1 month just to approve this action
lordship
plan?
Issued some orders for immediate approval and.
My lord.
We'll just hear Dr. Sukumar also on this.
Thank you, Your Honors. I would like to just make a set of observations on the thing so far. First is that there have been intensive discussions in the 3 or 4 months, and I think I concur with the presentation that Sri Manoj had just made about the progress so far. What I would say is that the action plan that is before the Honorable Court has the framework, the basic framework. It has the basic approach, and it has all the action points, the 10 pillars or whatever that Sri Nair has mentioned. I still think that there is a need for a little time for what I call site-specific management plan, because the area is extremely large. And the zonation approach has been taken, which I very much concur with, because it is in tune with the Karnataka Elephant Task Force report. With a little more challenges in Karnataka, because the habitats of Karnataka were much more compact, and therefore we only had 3 zones. Here there are 4 zones, zone 1, 2, 3, and 4. But this will require on-the-ground survey and verification, which in my opinion, cannot be done in 1 month. Sri Mohanty mentioned that in 1 month to be completed. 8 months are needed for sure, because, Your Honours, if the zonation is it's finalized and the maps are drawn, then we shouldn't have to go back and forth over and over again trying to do re-verification and so on. And a very good map has already been prepared by the Odisha Forest Department in consultation with all of us. But it requires ground verification, and that ground verification surveys, all that will take a little time, because the maps have to be drawn in a very rational and a scientific and a more practical manner. That's the first point. The second point is the whole issue of electrocution. I'm not the expert on the, how to maintain electric lines and so on and so forth. What I would submit is that zone 1 and zone 2, there is no questions that elephants have to be there in zone 1 and zone 2. And these are areas that have to be made shock-proof for the elephants on a priority basis. So we make sure, I'm not sure what proportion of the electrocution are taking place in zone 1 or zone 2. But on a priority basis, because most of the elephants are here, zone 1 and zone 2 will have to be made shock-proof in the first instance. And they are very relatively well-defined zones. And therefore, it can be done. Zone 3 and zone 4 are going to be challenges. Zone 4 is elephant exclusion zone, and that covers about 70% of Odisha, or 60% or 70% of Odisha. So to make all that shock-proof, to take steps underground cabling, or the transmission line should be above 18 feet and so on and so forth, all that is going to be not possible in zone 4. In zone 3, which is a conflict management zone, maybe to some limited extent it is possible. But what I would say is that first priority, zone 1, zone 2 especially, where the elephants are now just coming out to the forest areas, right at that interface with human habitation settlement, that has to be made shock-proof. The third is that the issue of wild pig came up. A lot of the electrocution cases, and I'm seeing this across the country over last several decades. The hooking of lines that was mentioned is actually a phenomenon which has been there more sort of north of the Godavari River, if I may use that term. It is not the south of the river. There is electrocution there also. But that's when the farmers connect directly from the house, the mains, the 230-volt mains, and they do the electrocution. Typically, hooking is not there. But a lot of this hooking and deaths are there in central India, Jharkhand, and all these other places, and in other parts of the country also. But that is primarily because they are not deliberately keeping it for elephant, largely wild pig. Your Honours, in recent weeks, there has been a lot of debate among the conservation community in India, desirability or otherwise of population control of wild pig. And the wild pig, by all accounts, has proliferated to such an extent, not just in the forest areas, they are coming out and largely in agricultural landscapes, where I don't think they have any ecological role directly. The whole issue of whether you can harvest them. The debate has been, generally people concede that some amount of harvesting of them for subsistence and providing meat to local communities should be accepted. In fact, National Board for Wildlife Standing Committee has also already approved such a thing. But then the debate got a little larger about commercial hunting. I would not get into that debate at this stage. Commercial hunting will not be advisable. But definitely as a policy, I think the state can come up with a policy in tune with also central policies and directions and so on for seeing how the wild pig population can be managed. That will be a great boon to the elephants and other larger creatures which are like collateral. They suffer from collateral in the whole process, Your Honor. And the last point is about, of course, the corridors, because this requires surveys across the entire state. About a year, because as I mentioned last time, both the dry season and the wet season of the elephant has to be seen, how they are moving. So that will take about a year, Your Honor. So these are my brief observations, and I would be happy to answer any other any questions you might have. Thank you.
All right. Yes.
Lordship, with your permission.
1 minute, sir. 1 minute. Let the counsel here speak. He also wants to speak. Yes.
My lord, I may be allowed to. My lord, I have, my lord. Okay. May I, my lord?
I'm asking you to speak, sir.
Yes, my lord. My lord, I have submitted a small report, my lord. Kindly have a glance on 16th. I had visited this village, my lord. This is Bokua, which is situated around 70 kilometers away from Jasipur, where this protects assistant belongs to, my lord, and how he has been murdered, my lord. I met the wife of
you give all these inputs to the investigating officer.
My lord, the affair has been lost, my lord.
So you give all these inputs to the investigating officers.
My lord, the affair which is lost by the wife of the deceased person, no action has been taken out, my lord.
So you contact the investigating officer.
And my lord, who is the person who has declared that he has committed suicide, my lord?
Sir, now that you have taken upon yourself the task of investigation, you better cooperate.
No, I have not.
You have undertaken your own investigation.
The affair which is lost in the Jasipur.
They are impressed with the photograph you've taken.
No,
yourself, not all of them.
No, not impressed.
So that's okay.
I want to the fact, my lord, that the affair number 320. Which is lost in the Jasipur on 21st of December, my lord. And now it is 17th January, my lord. No action has been taken up, my lord. Neither statement has been recorded, my lord. No step has been taken.
Permit you to talk to the investigating officer.
And those accused person has already been bailed out, my lord.
If you don't want to listen, then it's up to you.
Yes, my lord. But it is my duty, my lord, to intimate the honorable court, my lord. This is the situation.
But it's also your obligation to listen to us.
Yes.
You don't wish to listen, then that's
definitely, my lord.
That's all.
Because they are misguiding and misleading, my lord. The court.
My lord, pardon me to speak few words. Now we are talking about how the elephants to survive, but they don't have anything to eat. Though jungle is provided for the elephants, and we are not discussing about the elephants' food. But that is why from other states, elephants do come to this state and creating different problems. My lord, may pass a direction to the government.
Thank God you didn't tell me give a direction to the elephants.
No, not the elephants.
All right.
Your lordship, your lordship can direct us and the elephants also, but also the government.
All right.
But the government has thought of planting make plantations for the elephants. But that will, my lord, that will not
Please study the
be
problem.
done. It's
See,
only-
the problem is, I don't mind advocates arguing cases fully informed about the facts. You see, we make all kinds of loose suggestions. We must be conscious of what kind of submissions we're making. sir.
Oh, that's
We
like,
must be, see, these are very ticklish problems involving a lot of,
all the
scientific
all
studies
the
and
judges and people are making their head, but the things are not properly done.
I feel, sir, even as judges, we have forgotten what it is to be humble. Humble meaning humble in knowledge.
Yes.
The minute we start assuming we know everything, then there is no learning, sir. There's no learning. So look at the two of us. We can't simply start making random suggestions, can we? Because we don't know enough.
But thinking of planting, bamboo
See, this
plantation can be done quickly.
Sir, you are an expert, really, obviously. And you consider yourself an
Not
expert.
experts, I go to
No, you
jungles.
consider yourself an expert, which is, we have nothing to say on that. But we would like to actually get expert views on this, sir.
Expert
People
views.
who have actually dealt with these issues and are continuing to deal with this.
Well, we're not discussing about the food of the elephants. That's the difficulty. That your lordship to take into consideration. Unless the food is granted to them, given to them in forests.
If your lordship suggests, your lordship, let the affidavit be filed by electricity department in what their plan is to coordinate with the state wildlife departments.
Yes.
Let their plan be brought up also. Because there is an issue of coordination, your lordship.
So they've all been spoken to. This has been drawn up in consultation with them. So obviously their inputs have been taken, and then they have drawn up this plan. Yes. When those action points are drawn up, then we'll know what the role assigned to them is.
Yes.
Two deaths have been reported by electrification.
Lordship, your lordship
Yes.
is right while holding the view that one elephant died at Noyagarh district, lordship. It died 1 month, 45 days before at Noyagarh and Khurda border, lordship, by electrocution.
Intervener, na petitioner.
Lordship, in this case, because it is a public interest litigation, lordship, just I am, if your lordship will permit me, I can say few words, lordship.
But you're appearing in the matter, or you're just
he's not
participating?
neither is intervener, nothing.
It is a PIL matter, lordship, around 40 elephants. If your lordship permit, I will say. Otherwise, I will.
No, if you're there in the matter, it's okay, sir. Otherwise, it becomes free for all.
Nothing.
He has no abhinama for anybody,
All right.
either petitioner or intervener.
All right.
My lord, I pray this FIR number 320, a direction may be issued on behalf on this matter. Because they have sidelined this FIR, my lord. No step has been taken by the policeman. 1 minute. We can straight away ask. Yeah, the DSP is there.
Yes, sir.
You've been hearing this, Mr. Ashish Mishra's submission. He says there's an FIR 320
Sir.
at police station Jashipur.
Not
Jasipur.
Jashipur.
Sir, since that is reported at Jasipur police station, it is investigated by the IAC of that police station. I have no control over that police station.
It's
sir.
not about control, sir.
Control.
Immediately don't start talking in jurisdiction and police station wise. If you're not, suppose tomorrow there is a reported incident from Sambalpur or somewhere from Mayurbanj or somewhere from Anugul. Now we'll have to start calling the all of them into your task force, or you will simply wash your hands off.
Sir,
What is the meaning of a joint task force if the police representative in the task force is to turn around and say, sir, this is not my jurisdiction? Dr. Nair, I don't understand this. What is this going on?
Sir, we'll ensure that.
My lord, may I submit one thing? I will get specific instruction from the.
No, but we must have a police representative in the task force who doesn't say this is not my jurisdiction and that jurisdiction, not under my control. What is this going on?
This is not correct.
If there is an elephant death anywhere in the state, the police representative in this task force must know what to do. If he has to contact the IIC there, he has to contact.
Yes, sir. It's noted, sir.
This is perhaps with regard to suicide matter. Anyway, I will get the specific instruction from the
So wife of the
concerned
deceased person lost this complaint.
Yeah. We can't have a piecemeal approach like this. I don't know, what's his name?
Mr. Panda, I think.
Mr. Panda. It's not about whether you can control this investigation. You have to find out what is happening. That's all. Will the IIC at that place turn around and tell you, I'm not going to reply to you?
No, sir. If you will ask, you will tell me.
That is all we're asking you. We're not asking you to control him.
Yes, sir. Yes, sir. I can do, sir.
Yes. So please have a broad-based approach, a solution-finding approach. There are two approaches, how not to do the work and how to do the work. All right. For how not to do the work, we can find out many ways.
Sir, it is noted, sir. We'll ensure that such things don't happen.
Yes. Yes.
Your Lordship, with your kind permission, if I may be allowed to speak for 2 minutes regarding the habitat. Your Lordship, the Honorable Council has flagged rightly the point of elephant habitat improvement, Your Honor.
Yes.
If you were to look at, considerable thought we have given to it, because that is going to be the bedrock of our entire action plan. And if we don't develop elephant habitats in the medium and long run, entire action plan will be unviable. So
right.
It is, Your Honor, we have given due importance to that, and a whole pillar, a whole thematic approach, that is, we call it habitat management for increased productivity, specifically,
right.
Your Honor.
Right.
Even page number 38 has been given in it. I have had, under Dr. Sukumar's close guidance, a series of consultation with almost everybody who has worked on elephant habitats in India.
Habitat management.
We have looked at, within that, you've looked at stratification of elephant habitats, improving elephant habitat, and the ways to go about improving elephant habitats. Plantations, specifically, we have talked about bamboo. I clearly appreciate and understand the concerns raised by the council. So we have specifically recommended for plantations of bamboo, ficus, and preferred elephant food plants. We have drawn up a whole list according to which species could be planted in which area. And Dendroclamus strictus, that is Salia bamboo, is a very important elephant food resource. We have clearly mentioned that also. And also water resources and other things. So, sir, we have really taken into account this particular thing. And a fine-grained specific action plan for each division will also be prepared, and the funds allocated accordingly. Not that we're doing it right now, we're doing it in a
What
manner.
I can ask is, you share this maybe with them.
Yes, yes.
We have already shared, Your Honor.
So you have a copy of this report?
Yes. Yes.
You share it with him. You share it with him. All right. Yes.
Thank you, Your Honor. Thank you for allowing.
No. What about Dr. Sukumar's? I think that site-specific action plan he was talking about.
I think, Your Honor, if I'm not wrong, I can get clarified by Dr. Sukumar too. What Dr. Sukumar was mentioning, Your Honor, is that the zonation approach would require ground truthing.
Yes, ground verification. That's
ground
what
verification in some of the areas, so that we could clearly sort of stratify and freeze it. These are indicative according to available data. Second thing, what Dr. Sukumar was mentioning is about the corridor study, Your Honor, which would require a minimum of 1 year, because it needs to necessarily incorporate 2 different seasons. And the third one, which Dr. Sukumar was mentioning, was that
electrocution. He said zone 2 has to be made shockproof.
Absolutely, Your Honor. Absolutely. Absolutely.
No, so the concern about one of the council here about discoms, they are on board, correct? You have talked to them.
Your Honor, we have definitely spoken to them, but again, the point which he raised could also be an approach, Your Honor. It would be very nice if they also could be brought in formally under Honorable Court's.
No, that is, see, once you drop your action points,
right,
and they're given, a kind of a responsibility in that action point, then we can ask them to file an affidavit undertaking to carry out that obligation.
Yes, Your Honor. Yes, Your Honor. That would be much obliged and much appreciated, Your Honor.
All right. Because anyone else wants to say anything else? All right.
My lords,
Yes,
my lords,
yes, please.
in my matter, my lords, I'm appearing in person. In 2015, my lords, the lordships had asked the electricity distribution companies to be opposite parties. So in my case, they are already opposite parties. If they could be directed to file an affidavit as per your lordship's direction.
Okay. All right. All right. All right. This is the Tata companies, is it?
New.
Now they would be.
Yes, Your Honor. It is TPCODL, who is the operative electricity distribution company in this particular area.
So then, I mean, they are not actually, you'll have to substitute them, Ms. Padi. We'll anyway ask them to do it. All right. You see, Dr. Nair, the Chief Conservator of Forests, Additional Charge, has filed an affidavit dated 17 January 2023, enclosing the Single Court's comprehensive action plan for conservation of elephants and mitigation of human-elephant conflict in Odisha, unquote. Full stop. Dr. Nair, who appeared online, explained that the report contains an executive summary along with action points under a Single Court's 10-pillar strategy, with the 10 pillars being, just take from page 16, 1 to 10 paragraph. Dr. Nair took the court through the important aspects of the report, which deals inter alia with interdepartmental coordination, which in turn would require district level human wildlife conflict mitigation committees to be constituted under the chairmanship of the collector and having representatives of the superintendent of police and heads of relevant line departments, and the DFO being the member secretary. Full stop. The aspect of Single Court's human-elephant conflict mitigation requires adoption of a Single Court's zone-based approach, unquote, taking a cue from the report of the Karnataka Elephant Task Force. We'll stop 3 broad zones, namely Zone 1 bracket Elephant Conservation Zone, Zone 2 bracket Elephant Human Coexistence Zone, bracket Zone 3, I mean broadly 4 zones. Zone 3 bracket Conflict Mitigation Zone, and Zone 4 bracket Elephant Removal or Exclusion Zone have been envisaged. Stop. Separate strategies have been worked out for Single Court's protection, enforcement, and prosecution, unquote, as well as improving elephant habitat, corridors and connectivity, and people's participation, education and awareness. Full stop. Paragraph. In response to the concerns expressed by counsel appearing for the parties, Dr. Nair pointed out that the action plan also speaks of Single Court's habitat management for increased productivity, unquote, which would involve improving the elephant habitat, plantation of bamboo, ficus, and preferred elephant food plants, water sources and other habitat improvement measures, apart from forest fire prevention and control. Paragraph. One major concern in the past few months has been the increased deaths of elephants due to electrocution. To tackle this issue, the action plan proposes to involve the electricity distribution companies, bracket discoms, to provide solar fencing using the recently launched Jana Surakya Gajarakya. Full stop. A suggestion is for the use of portable bracket removable bracket solar fences, which has been found to be effective in Sri Lanka, and for it to be tried on a pilot basis in selected areas. Full stop. The court also, paragraph. Dr. Sukumar, who participated online, provided certain suggestions, made some suggestions regarding ground survey and verification preceding the maps to be drawn up. And for the elephant corridors to be studied on a more intensive basis. Full stop. He also emphasized the need to make zone 2, that is the elephant-human coexistence zone, single quotes, shock-proof, unquote, which would require steps to be taken to ensure there is no illegal hooking, single quotes are hooking, of electricity lines by local population anxious to protect their fields and crops from predatory attacks of wild pigs and boars, which in turn appears to be trapping elephants into deaths. Full stop. Paragraph. The court is informed that the comprehensive action plan would require to be approved by the Chief Secretary.
High Power Committee.
Would require to be approved by a High Power Committee of the Government of Orissa. Full stop. Considering that the action plan has been drawn up after consulting a wide range of actors, as well as experts, and the inputs of others as suggested by this court in its previous orders. And considering that the problem requires urgent attention, the court requests the High Power Committee to
My Lord, may direct the Chief Secretary to take a call
through the Chief Secretary to immediately take up this issue of approval of the comprehensive action plan without any delay. And preferably within a period of 2 weeks from today.
3 weeks maybe, because That is ensuing hockey.
That is all. Everything can go on simultaneously, sir.
Yes.
There are some issues. Elephants don't take a break because it's hockey.
Hockey
Stop everything.
So,
And this order may be communicated to the
yes.
from the registry.
Yes, please. This is to ensure that the action plan is immediately rolled out
3 weeks.
and the action points are worked out on the basis of such action plan. Full stop. Dr. Nair informed the court that the action points will be finalized within a month thereafter. Full stop.
Lordship, could I make a very small suggestion?
Yes.
Could I request that the term fire management be substituted for fire prevention? Fire
I see.
prevention is a part of management, but it can go beyond that to prescribe burning and so on, which might actually be favorable for the habitat. So the term fire management rather than fire prevention. Your Lordship. Thank you.
All right. Did we use that? Did we dictate fire management? I don't know. Or is it in the report?
Fire prevention. I don't know if it is in the report. I also told Dr. Nair to substitute fire prevention with fire management.
I see. All right.
There could be prescribed burning that might be necessary for the promoting the growth of grasses or keeping grasslands and meadows and so on.
Yeah.
So in the report, it is fire management, Your Honor, but
All right.
dictating you said fire prevention, Your Honor.
All right.
Yeah.
Okay. All right. Paragraph. You say, Mr. Ashish Mishra, learned counsel for the petitioner in Writ Petition Civil 14706 of 2022, placed a report of his personal visit to village Bakwa, located inside the Simlipal Wildlife Sanctuary, and expressed concern that no steps were being taken to further investigate FIR number 320, dated 21st December 2022, registered at PS Jashipur in Mayurbhanj district, concerning the death of
Protect assistant.
Turam Purti, right?
Yes, ma'am. Purampur.
Who purportedly was an eyewitness to the death of an elephant by burning at Garandia (Jenabil range) in the Simlipal forest. Full stop. Mr. Panda, the DSP, is it?
Additional SP.
The additional SP,
Member
part
of
the
JTF.
JTF, who was present online, has undertaken to contact the inspector in charge of PS Jashipur to ascertain the progress of the investigation into the said case. Full stop. The court will be informed of the progress on the next date. Paragraph. The court notes with some concern Dr. Panda's submission that 3 of the forest officials who had been arrested in the said case were subsequently granted bail and have thereafter not been able to be traced despite issuance of non-bailable warrants. First of the court would like to emphasize the need to need for the police to follow up on these issues with urgency and complete the investigation by taking it to the logical conclusion without unnecessary delay. Full stop. In the previous order, dated 15th November 2022, 13th December, is it? 22nd December, 22nd December 2022. The court noted the assurance that the charge sheet would be filed at an early date and now notes with some concern that charge sheet is yet to be filed. So it is expected that by the next date, the charge sheet in the said case would have been filed. Full stop. The court also notes that the specific action points regarding single court's crime detection, inquiry and prosecution in terms of the comprehensive action plan are to be fixed and implemented without any delay. Full stop. I think we'll have it in early March itself.
March.
So that
Yes, please.
1 month of implementation.
My lord, may I direct
Action
that
plan.
this order may be directly communicated
Yes, yes.
to Chief Secretary.
All right. Court requests the JTF to file a further affidavit before the next date, enclosing the action points drawn up on the basis of the comprehensive action plan. Full stop. Paragraph, you say the Ms. Mrinalini Padi, the petitioner in writ petition civil 19625 2015 pointed out that she had already implemented the discoms as opposite parties. Full stop. She undertakes to file an application to implement the present entities so that directions can be issued to them on the next date to file affidavits in response to the action points to be fixed by the JTF. Paragraph. List on I think we'll fix it on 13th only.
13 March.
13 March at 10:30 a.m.
This order may be communicated.
A copy of this order be communicated forthwith to the Chief Secretary. Thank you, Dr. Sukumar.
Probably the members of the JTF, they have to be present.
Yeah, the members of the JTF will remain present. I'm sure Dr. Nair will be present.
They will remain present on each and every.
All right,
irrespective of any direction.
All right. We appreciate the efforts made by the JTF in drawing up the action plan.
Thank you very much, sir.
Thank you.
It's under your direction and your push that we are able to do it in such a short time. Thank you very much.
All
sir.
right. All right. All right.
I love this.
All right. Thank you. None of his.
This is a matter in which public health is in stake due to the formation of Liquor Commission. And for that, as the cigar has been prohibited, likewise, the liquor can be prohibited, which causes a lot of family disturbances, death due to accident and also health hazards, which causes severe loss to the state exchequer on paying compensation to that also. It is even more than the profit it is getting out of that liquor business. So
I think regarding total prohibition, your lordship has already passed a judgment
Yeah.
in Arun Kumar Budhia versus State. That
What's that? Where's that judgment?
That I will give within
All right.
10.
where a notice can be issued, and I will provide all necessary answers to your good self that how it is, what is the in their judgment. I have not gone through. I will go through after getting the.
No, but we've already taken a view on that. So,
Millard, here I may be permitted to place the different view. That may be the one side of the coin has been seen. I will place before other.
you'll have to take it up at a different level then. We can't advise you what you should do. But we've taken a view that there are limitations to the directions we can issue in this matter.
A notice may kindly be issued.
No, we've already done that in that matter. We'll go in a judgment also.
Millard, if the judgment has been passed by your lordships, it can be reviewed. I am placing a fresh matter. This notice may kindly be issued.
You first study the judgment. You study the judgment and then you can always file a fresh petition. This is
Yes,
not time bound.
Then this matter may kindly placed in some other day.
No. You file a fresh petition. You'll have to study the judgment. You'll have to tell us why we need to reconsider and all that. You see, in view of the recent judgment of this court in Arun Kumar Budhia versus State of Orissa,
kindly fixed by that time. I will go.
The court is not inclined to take a different view. Full stop. Moreover, counsel the petitioner states that in this matter, which involves the same issue, full stop. Moreover, counsel the petitioner states that she needs to study the judgment and then perhaps file a fresh petition. Full stop. Permitting her to do so, the petition is disposed of. Right.
Obliged.
None appears dismissed.
May I please your lordship? Your lordship may kindly come to page 37 of the tribunal's order, my lord. Paragraph 4, my lord. The learned SCST in its order dated 15/4/2008 has confirmed the aforesaid order of assessment passed by the learned STO. From the aforesaid two orders, it is found that there is no cavil of doubt that the assessment proceeding under Section 9 of the OIT Act was completed on issuing notice under Section 12(8) of the OIT Act. Then your lordship may kindly come to page 38. Last paragraph, my lord, of the tribunal's order. In the result, the appeal is allowed. The order passed by the fora below are quashed, and the matter is remanded to the learned STO for taking of fresh assessment after complying with the provisions of OIT Act and rules, and shall complete the assessment within 3 months from the date of receipt of this order. After 4 years, the learned STO initiated proceeding at page 39, my lord. 39, my lord. After 4 years, by taking cognizance of Section 10(3) of the OIT Act, my lord. Section 10(3), my lord. Your lordship may kindly see Section 10(3).
What you've challenged is the new fresh assessment order pursuant to this.
Yeah, pursuant to this
tribunal's order, a fresh assessment order has been passed.
Again.
So why have you come directly here? Why have you come directly here?
My lord, complete illegality, my lord.
All that you can urge in the appeal. You can always urge all that in the appeal. You know that. Permitting the petitioner to file an appeal against the impugned assessment order in accordance with law, the petition is disposed of. If such appeal is filed not later than 1st March, accompanied by an application of continuation of delay, explaining the delay on account of the pendency of the present petition, to be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view in the matter. Originals of all annexures be returned, subject to being substituted with attested photocopies.
Delay may kindly be condoned, my lord.
No, that they will do it, sir. We've already said all this.
Yes, my lord. Obliged.
All right.
Item number 5. Item number 5, Millets.
Yes.
This matter is connected to Millets WPC number 1087 of 2008. Your lordship earlier by order dated 7/8/2009 directed to tag up this matter with that, Millets. I'm showing a copy of my earlier. Because this matter relates to interest bills pertaining to the entry tax. But let me clarify one thing. Just a minute. Clarify one thing. My lords have adjourned all interest matters to 2nd of February.
Mm.
And other batch of petitions, your lordship is calling on 13/3/2023, my lords. The difference between two is that, let's so far as 29/3/2007 orders of the Honorable Apex 29/3/2017 orders of the Honorable Apex Committee concerned, my lord, it has gone finality. It has attained finality. Well, my lords have dismissed all the SL filed by the pursuant to the 9 judgment. But so far as other small batch of SLPs which are filed, they are potentially import, my lords.
Right.
Your lordship permitted the petition, the Honorable Apex to permit a petition to file revival application.
Right.
My lords have allowed revival, admitted the matters, and those matters your lordship have directed to call on 13/3/2023, and this is one of such matters.
I see.
So therefore,
Your Lordship,
Alright.
Your Lordship, from the
30th
beginning,
March.
Your Lordship, only in that respect, so far as that imported goods is concerned, Your Lordship, from the beginning, I have mentioned the same thing, Your Lordship, prior to all the previous dates, Your Lordship. Your Lordship, in all those imported goods matter, Your Lordship, no stay has been granted, Your
Correct.
Lordship.
Correct.
Your Lordship, in this case has been tagged with this case, and interim order has been granted by saying that it is interest case, as like as interest case. So, Your Lordship, let this matter be there, and I may be
no,
later.
I have complied with your lordship direction in this case, my lord, by paying the entire tax, and also interest your lordship directed, whatever interest your lordship directed after the subsequent order, that also I have complied with.
All right.
The question is, my lord, one thing also, let me be very clear, subject to my friend's reaction on this, my lords. Whereas, your my lords may kindly see. Whereas now Anti-Tax Act has been declared to be, my lords, intra-affairs. But so far the phrase round of matter now that has come by for revival, is supposing tomorrow your lordship comes to a conclusion based on the very limited question of discrimination, that it is because 9 judge bench has also allowed the this honorable court, my lords, to independently take into account whether the statute is, my lords, at all suffering from, my lords, the virus, my lords, the element of discrimination or hostile discrimination in terms of Article 304B, my lords. Supposing tomorrow your lordship comes to a conclusion that it is ultra-vires on account of this discrimination, my lords, then, my lords, the entire statute goes as the interest matter, whatever your lordship is going to take up on 2nd of February, my lords, so that becomes again. So my humble submission is, let the 13/3 matter be taken up fast. Supposing if state succeeds, well and good.
Yeah, that is
if state
very limited. Your Lordship, in that,
and you cannot force.
He's already arguing for adjournment of 2nd February.
Anyway, so let my matter be there on 30.
All right. List along with writ petition civil 1087 of 2008 on 13th March.
Deeply obliged.
All right.
Item number 6.
May I please? Similar order may be passed. May I please?
Item 6.
Similar order may be passed. Item 24th, my lord, also same. Fine.
Same order.
Yes, ma'am.
All right.
24 also same.
All right.
Item number 7.
Manifest dismissed. Achha, the memo is taken and record. Dismissed as instructions.
Item number 8.
Okay. Dismissed as withdrawn.
Supplementary list item number 9.
My lord, the petitioner here challenges the order passed by the Principal Secretary to Government Excise Department rejecting the representation of the petitioner for seeking of 35% of COVID fee, my lord. Your lordship has already issued notice in similar item and fixed it to 28/6.
28/6.
Same order. Along with, yeah. All right.
My lord, item 26 and 27 same.
Same. All right.
Item number 10.
Item number 10 to 13 are identical matters. Your lordship have earlier disposed of two dismissing the STRB relying upon that Sri Jagannath Thakur's But only one thing what I was striving all through before Lordship to be argued, Honorable Apex Court said that had this ground been taken before the High Court, which you have not taken, we could have considered. So that may or that ground, because the last occasion also I faintly succeeded before Lordship, your Lordship did not. There are two supremo judgments. Your Lordship on that day has not taken consideration. That one Pornomi Mills case, 65 STC page 1 million, and Bakul Oil Industry, saying that once a notification is issued, supposing it grants some concession, and concession period is 5 years.
Yes.
Within that concession period, there cannot be abridgment of grant of
same party, sir. It's not even a different party. We'll have to follow this order only. Following the order passed with this court on 21st June 2022 in STREV 524 and 525 2008, bracket Eastern Confessional Limited versus State of Orissa. These revision petitions are dismissed. All right.
Now, one small additional prayer. Now that I have not, I am failing in this, my lords, and my lords knows, I was enjoying stay all through before dismissal of my lords, the SLP upon the Apex Court. The entire balance now demand becomes due to recoverable. Factories are closed for years, my lords. So may I be permitted to approach the commissioner with the lordship's liberty to grant installment or some consideration?
That you can always do, sir. We don't need liberty. You can always do that. You can always do that. All right.
My lord, that prohibition matter, that is order dated 29/6/2022, passed in WPC 13523 of 2013. That Mrs. Kiran Jena was one WPC 13523 of 2013, order dated 29th June 2022. Arun Kumar Budhia versus State of Orissa.
Some others.
10 to 30 are same.
Same. Correct.
Item number 14. 14, my lord, so states revision, my lord. The question of law at page 24 of the revision petition. Question number 1, whether on the facts and in the circumstances of the case, the tribunal is not justified in deleting the imposition of penalty in exercise of power under section 42(5) of the Orissa.
So notice returnable, when is that? No. Notice returnable. All the 42(5) matters are coming up on some date. No?
Different dates, sir.
Different dates, is it?
Yes, ma'am.
All right. 4th July.
Item 15.
May I please? Here, the defect as indicated, copy has already solved. And so far, limitation part is concerned, there is no limitation because I have received the order in 11/2/21 and filed on 9/3/21. So that is within the limitation. So that may be ignored now. I have offered in para.
So this is Keshav Automobiles.
Sorry? Keshav Automobile. One part, total part will not cover. Part of the
1/4/2013 to 31st March 2017.
Yes, that will cover. Rest will not cover. The second question is not whether royalty is a tax or not. That has been pending by Supreme Court in full bench.
11 judges.
Indian Smiths lots.
All right.
Yes, sir.
Admit the following questions are framed for consideration. Take 1A and D, pages 6 and 7, A and D. As far as question A is concerned, in view of the judgment of this court in Keshav Automobiles, affirmed by the Supreme Court in Rathi Steel, the impugned assessment as far as the period 1/4/2013 to 31st March 2017 is hereby set aside. Impugned assessment order and the corresponding orders of the First Appellate Authority and Tribunal are set aside. Full stop. Question A is accordingly answered. Paragraph. As far as question D is concerned, the issue is stated to be pending in the Supreme Court of India, permitting the parties to mention for listing after the disposal of the case in the Supreme Court of India. The present petition is adjourned sine die.
IA may be disposed of, so far dispensing.
Yeah, IA is disposed of. Just a question, just look at the question in that they put 17.
Mr. Satpathy, that amendment has come into effect from 1/10/2015.
Yes.
You have framed the question up to 2017.
Yes. One part will be deleted.
So 1st October to 31st March 2017 is live.
Covered by my lord's order, my lord, I have just supplied my lord. Sahu brother, please.
One part has to be.
Yeah. Insofar as it concerns up to the period 30th September 2015 is ever set aside. All right. And then you reproduce this, the matter is remanded.
22 is infructuous, Your Lordship. Kindly mark it. I have some other cases.
All right. 22 dismissed as infructuous.
Item number 16.
On behalf of Mr. R.N. Pal, kindly taken up next week, item 16 and 17.
Why, sir?
He is ill today. On behalf of Mr. R.N.
Ill?
Pal, he is ill today. Kindly taken up next week.
Stated to be unwell. List on 21st August.
Item 16 and 17.
Yes.
Copy has not been solved, my lord, in both the cases.
Meanwhile, defects be removed. All right.
Item number 18.
None appears dismissed.
Item number 19.
Please, Your Lordship. The petitioners are limited grievance that the scheme introduced under Annexure 1, the most popular scheme of Kalia Yojana by the government of Orissa. There, the in availability of the budgetary fund, the government decided under Annexure 2 to Orissa contingency fund to implement the scheme. So thereafter, when these allegations from irregular distribution and ineligible beneficiaries selected, the opposite party number 4, the AG Odisha, under Annexure 3, page 21, so took the cognizance and decided to undertake the special audit. When the special audit could not be conducted in time, the petitioner under Annexure 4, page 22, he submitted a representation. There, his petitioner has described all these facts and innovated with
there is a proof of submission of the representation, sir.
My lord. That, my lord.
Proof of communication.
That
Receipt,
annexures included in the representation. The annex, but that was not rightly available petition. It was, but it is submitted.
A stamp, right in the beginning of page 22. There is a stamp.
There is a stamp. It's page 22.
Yes. All right. The petitioner's representation, bracket Annexure 4, will be examined by the
opposite party number 8.
Principal Accountant General, Economic and Revenue Sector Audit, Odisha. And after notice to the petitioner and giving him a hearing on a date to be intimated to him at least 10 days in advance, a reasoned order shall be passed thereon by opposite party number 8. On or before 1st May 2023. And be communicated to the petitioner within a week thereafter. Court clarifies it is not expressed in any matter.
Opportunity of hearing so that petitioner can oblige.
Item number 20.
For establishment of petrol pump, my lord, there the repairs are pending before the opposite partner 2, my lord. Will going to be issued NOC, my lord. And that is a entire area is residential area, my lord. And there is a guideline of the Central Pollution Board. Within 50 meters, there is no construction is made for the petrol pump, my lord. And villagers and the
because here NOC has not been issued yet. It is under consideration. So let's
the representation be considered.
Yes, ma'am.
The petitioner's representation, bracket Annexure 4, shall be examined by the collector.
Yes, ma'am. Opposite 2.
Collector Khorda, and after notice the petitioners as well as opposite party number 4. And after giving them a hearing, a reasoned order thereon should be passed not later than 13th March 2023. The order shall be made available to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Item number 21.
In this case, my lord, opposite party number 4 to 10, though they encroach and the LE case is initiated. So, my lord, my representation by the Annex 1 page 7 is pending. And earlier filed this application, lordship is a liberty, though I am not enabled to give the proof, my lord.
Right. Okay. The petitioner's representation, bracket Annexure 1.
Yes, my lord.
Shall be examined by the
Tahsildar Bhadrak.
Tahsildar Bhadrak. And after notice the petitioner and opposite parties 4 to 10 and giving them a hearing, a reasoned order should be passed thereon not later than 3rd April and be made available to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Item number 23.
My lord, I'll not talking the annexure 1 is before collector, my lord.
But these encroachment cases and all, Tahsildar.
He can also examine.
Yes, my lord. Then my annexure 2. If lost my
All right, either way, sir, no problem. All right, annexure 2 is petitioner's representation bracket annexure 2. All right.
Item number 23.
23, my lord, the entry tax interest matter, my lord. 2nd February.
All right, list on 2nd February.
Obliged.
Item number 25.
24 is over. All right.
24 is item number 6.
All right. None appears dismissed.
26, 27 number. Item number 28.
My lord, this is arising out of intra-court appeal, my lord. And this is regarding a payment of compensation under Land Acquisition Act, my lord. And I may be permitted to remove the defect, my lord.
That's okay. What's the matter about?
Let's see, keep it to next week, my lord. I will argue, my lord.
April is a division bench order.
Yes, my lord.
How do you file a writ appeal? How can a writ appeal be filed against a division bench order?
Against the division bench order, writ appeal is not maintainable. It is only honorable single judge. That is only maintainable in writ appeal.
Answer for the appellant seeks.
I will argue, my lord. Keep it to next week, my lord.
If you want to withdraw it or be dismissed.
I may be permitted to withdraw.
Counsel, the appellant seeks leave to withdraw the present appeal with ability to seek other appropriate remedies may be available to the appellant in accordance with law. This post office is withdrawn with liberty is paid.
Although the land was acquired by the government since my lord.
Now don't argue, madam. It's a division bench order. We can't have an appeal against that. All right.
Item 29.
Obliged.
Item number 29.
29, my lord. 1 week time may be granted, my lord, so that I will file fresh notice to opposite partner.
No, what's the matter about?
Well, this is a case. The writ application has been dismissed for non-prosecution. And that is why, my lord, my limitation application was also dismissed as well. That is why, my lord, writ application has been filed.
We already granted in October itself, sir. Time was granted to the appellant to ascertain the present correct address of respondents 4 to 6 way back on 20th October 2022. Full stop till date, no steps have been taken by the appellant. Court, considering that this is a matter of 2018, the court does not consider it appropriate to grant any further indulgence. The writ appeal is dismissed.
My lord, I may be pardoned to say, my lord, I have a very good case on merit, my lord. So far as, my lord, he is residing therein, but in spite of this, my lord, he did not receive my notice. My lord, he is residing therein. On last occasion, your lordship directed me to file fresh requisites on the correct address. My lord, I ascertained that he is residing therein. That is why, my lord, there was no occasion on my part to file fresh notice on this address.
Then whatever you have to give an explanation, you have to file an application here asking for clarification. You can sleep over it. From October, you're now sleeping for the last 3 months.
My lord, this is a case, my lord, where Jagir land has been given to me.
And what is wrong with the impugned order? Okay, let's come to the 26th November 2018 order. What is wrong with it?
Well, I have prepared a dead chart, my lord.
No. Just
yes. Yes. My lord, on
26th November 2018.
Yes.
Yes.
26/11/2018. Page 20, my lord. You'll also make kind page 20. And only on point of delay, my lord, it has been dismissed.
What's the explanation of the delay?
There is a delay of 484 days in filing the restoration application, and this court, by order dated 5/10/2016, had directed issuance of notice to the opposite parties in the matter of limitation.
it appears from the office note,
What
neither
is the
the AD nor
explanation of the delay, sir? What is the explanation for 484 days delay?
my lord. My lord, I have filed a limitation application under Annex 2. Here I have stated that in April 2012, the conducting counsel, my lord, Mr. B.K. Kaur, he died. My lord, that was not in my knowledge. My lord, when I came to know that my conducting counsel is dead, I engaged another London counsel to appear, and that is on 2/9/2015. By that time also, my lord, I had no knowledge that all those things have happened. Behind my back, this case has been dismissed for default because of non-prosecution, because the conducting counsel is dead. So, my lord, my newly engaged counsel, he filed Vakalatnama, also filed substitution application along with the Vakalatnama. Well, by that time, had I been knowledge regarding all those things, I would not have filed substitution application. Well, I could have resorted to file a restoration application by engaging my new counsel. That was not my knowledge. In spite of this matter, I filed repeated memos for listing of this matter. And when this matter was not listed, I made an inquiry from the registry and came to know that this matter has been dismissed for default since 4/5/2015. And that knowledge was, my lord, I got this knowledge on 8/9/2016. Thereafter, my lord, immediately on 29/9/2016, I filed restoration application. And notice was issued, all those things was happened, and on 26/11/2018, my matter was dismissed for default. My lord, I humbly submit before your lordship, my lord, I have a very good case on merit, my lord. Had I been placed all those things before this honorable court, matter would have been different. It's a Jagged land, my lord, I have purchased this land. 50% share was given by the London CEO, and it was also confirmed by the London Deputy Director. Other side has not come to the higher forum. I came to the higher forum in saying that 50% land should not be given. Entire land should have been given to me because I have purchased this land. Other side is not coming forward. He is ready with the ascertainment which was given to him. What land has been allotted to him. I came to higher forum saying that I should have been given 100% of land. My lord, entire 50% along with all lands were declined to be given to me. My lord, either 50%, which was confirmed by both the courts, London CEO, London Deputy Director, London Commissioner hold, that you are not entitled to get any land even. My lord, that is how, my lord, I being a purchaser, my lord, I have a very good case, my lord. Altogether, I will lose my right. Your lordship may kindly, for a point of limitation, my lord, I may not be deprived to get my land.
All right. The present appeal is directed against an order dated 26 November 2018, passed by the London Single Judge, dismissing CMAPL number 535/2016, which is an application for continuation of delay 484 days in filing the restoration application. Paragraph. Writ petition civil 5968/2002, filed by the present appellant, was dismissed for non-prosecution way back on 4th May 2015. Full stop. The explanation offered for the delay in filing the restoration application was that the counsel conducting the case had expired, and this was not within the knowledge of the petitioner. Full stop. Subsequent counsel who was engaged also did not take effective steps immediately. So the court finds that the delay of 484 days is indeed extraordinary. Stop. It was expected that the appellant should follow up the matter with his counsel on a reasonable basis periodically. Full stop. Clearly, the appellant did not do that. Full stop. The court is unable to find any error having been committed by the London Single Judge in declining to condone the extraordinary delay of 484 days. Stop. Consequently, no grounds are weighed out for interference. The appeal is dismissed.
Item number 30.
My lord, may I be allowed to, my lord, I may take recourse of any other provisions of law, my lord. That I may be liberty may be given, my lord. Your lordship knows, my lord, I have purchased this land. For altogether, my lord, this innocent person will be suffered, my lord. Even though I, my lord, committed a mistake, my lord, for the commission of mistake at the instance of a lawyer, my lord, party should not suffer.
All right.
That liberty may be given, my lord. for the sake of.
All right.
Item number 30.
30 miler infractures.
Dismisses infractions.
Item number 31.
None appeals dismissed.
Item number 32.
Please, Your Lordship. In this case, my lord, some Odia vernacular annexures are there. I am permitted to. I am permitted to 1 week time, my lord, to file
Tell us what the matter
English
is
translation.
Tell us what the matter is about.
So, matter, my lord, the appellant, my lord, approach this honorable court, my lord, challenging the order of the honorable single judge, my lord. Lordship can have a glance. The order, what was passed by this honorable court, single judge, my lord. While adjudicating the case, my lord, the honorable single judge, my lord, viewed that the center was not approved and so also the appointment was not approved. Though the appellant was engaged by the village education committee as an education volunteer, and that was confirmed by the village education committee, and the center was also approved by the district project coordinator as per the guidelines issued by the government. Though she was legally and my lord, by the appropriate authority having appointed as an education volunteer continuing, and after abolition of that education volunteer scheme, though the government formulated a scheme for their rehabilitation in the as a para teacher, she have been deprived, against which she approved this honorable court. But honorable single judge, my lord, viewed that the center was not approved, the appointment was not approved. That is why she cannot claim. Lordship kindly have a glance for a moment, my lord. Annexure 2, Lordship kindly have a glance.
Yes.
Annexure 2, page 70.
Yes.
And here, my lord, the block development officer, Pujang. Here, my lord, Constitutional Village Education Committee for EGS Center. I am placing, my lord. I will be pleased to intimate you that the district level EGS committee has approved the EGS center to be opened in the hamlet Tarapada of village Gudu Pay. You are hereby directed to form village education committee of the EGS center by 1st week of August 2022, my lord. Thereafter, my lord, village education committee was formed. Annexure 3, my lord. That is the Odia version, my lord. Annexure 3, my lord, page 18, my lord. The committee was formed. And as per the guideline, committee is empowered, my lord, to give selection and appointment to the education volunteer. Accordingly, Annexure 4, the committee was unanimously committee resolved to appoint the 3 persons as recommended 3 persons as education volunteers, my lord. When in which the name of the appellant was placed at the top of the serial, at serial number 1. And as per guideline, though since the education, the village education committee selected the appellant and placed it at serial number 1, she should be given engagement as education volunteers. Accordingly, agreement was executed by the village education committee and she was allowed to continue. But thereafter, after continuance, that scheme was abolished. And you'll also have Annexure 5, page 22, my lord. In view of that government resolution, government decision, government, I'm placing, my lord, government after careful consideration, and I'm placing at the top, for the purpose of universalization of elementary education guarantee scheme, EGS, an integral part of the Sarva Shiksha Abhijan, was operational in the Orissa from the year 2001-2 due to upgradation of EGS centers to regular schools, and for various reasons, the education volunteers engaged in such EGS center have been disengaged and would be facing disengagement in the above process. Government, after careful consideration of the problems of the education volunteers under the education guarantee scheme, decided to rehabilitate the education volunteers in EGS centers who have been disengaged or facing disengagement under the education guarantee scheme on the following manner. Such disengaged education volunteer will be rehabilitated as Gana Shiksha under Sarva Shiksha Abhijan
since the education EGS scheme was abolished, and they should have been, the applicant should have been rehabilitated as Ganashikyak, but they have not given the engagement to the applicant as a Ganashikyak. And she approached this honorable court. This honorable court in the earlier writ petition directed to the collector to consider the case of the applicant. And the applicant case was not considered positively, and against which is the again the applicant approached this honorable court. While adjudicating the matter, honorable single judge viewed that the center was not sanctioned, not approved, the appointment was not approved, she was not continuing. That is why she cannot be rightly government rejected, not rehabilitating her as a Ganashikya. This is the minor case, minor. But as per the guideline, minor, she should have been given. She should have been rehabilitated as a Ganashikya, since she was rightly and lawfully engaged as a Ganashikya by the village education committee.
Present appeal is directed against the judgment dated 21st November 2019, passed by the Learned Single Judge, dismissing the appellant's writ petition civil 32527 of 2011. Paragraph. The petitioner had challenged before the Learned Single Judge in the above writ petition an order dated 4th October 2008, passed by the collector Jagat Singh Poor, rejecting the claim of the appellant to be absorbed as Ganashikyak. Bracket. The Learned Single Judge noted that the appellant's claim for absorption was based on the premise that she was continuing as single quotes education volunteer, unquote, at the Tarapada EGS Center of village Gandakipur of Kujanga block. Paragraph. However, the records did not show that the appellant had in fact been selected to be engaged as EV at the above center by the district level EGS committee Jagat Singh Poor. Full stop. Paragraph. In response to the order passed by the Learned Single Judge earlier on 30th July 2008, in writ petition civil 9745 2008, requiring the representation of the appellant to be considered, the collector called for a report from the district project coordinator, SSA, Jagat Singh Poor. Full stop. The district project coordinator then submitted his views. Full stop. He stated that the appellant had not been selected as EVC for the Tarapada EGS Center, and her name was not mentioned in the selection list, EGS selection list prepared by the competent authority. Paragraph. There was also no recommendation by the district level EGS committee approving the appellant's name to be an education volunteer. Full stop. No remuneration as such had been paid to her as education volunteer of the Tarapada EGS Center, which was itself non-functional at the time of the order passed by the Learned Single Judge. Paragraph. Since factually the appellant was unable to establish that she had been engaged as EV in the Tarapada EGS Center, the question of the Learned Single Judge interfering with the impugned order of the collector, rejecting her claim for absorption, cannot be faulted. Paragraph. No grounds have been made out for interference, and writ appeal is dismissed.
Item 33.
33 kind of taken up after lunch, man.
Why?
She's in another court.
All right. Just pass over. We don't know about after lunch.
Item 34.
35, 36, 40, 41 and 40. Obliged.
Item number 37.
May I please your lordship? My lordship, on behalf of Mr. Mahapatra, my lord, item 37 and 38 permitted to withdraw, my lord.
Or dismisses withdraw.
Obliged, my lord.
Item number 39.
No instructions dismissed.
Item number 40. Sorry. 40. Item 40. Item number 43. May I be permitted to place through virtual mode, lordship?
Yes.
Milord, here, my lords, this impugned order passed by the Honorable Single Judge is at Annexure 4, page 32, my lords. And the case where, my lords, the Honorable Single Judge has been pleased to, the operative portion is at page 37, my lords, that Honorable Single Judge has been pleased to direct the corporation to pay this realization of 1,98,842, lordship. Now, lordship, so far this relates to, my lords, this certificate proceeding, my lords, where, my lords, the opposite party number 5 workman has claimed subsistence allowance under revised scale of pay, my lords. Although, my lords, we had placed before the Honorable Single Judge that this revised scale of pay is not applicable at that time, and it was made a.
Sir, have you implemented the order of the single judge?
My lords, we have paid 1 lakh. That is at page 24, lordship. Page 24, lords. Kindly have a glance.
No. Just answer yes or no, sir. Have you implemented the order of the learned single judge?
No, we have not. We have not paid 41,379, lords. We have already paid, and the only my submission, humble submission.
Sir, please answer the question correctly, sir. If you don't mind.
Yes, sir. I'm sorry.
The learned single judge has given you a direction.
Yes, lordship.
Have you complied with the direction, sir?
No, lordship. We have not complied. Lordship,
So when do you propose to comply, sir?
Lord, we will comply, my lord, within 4 weeks. Only one submission before.
Within a week?
Within 4 weeks, lordship, because the differential amount we have already paid. Page 22 is that.
No, this you are to pay immediately, right? The order of the single judge is dated 6th February 2020.
Lordship.
3 years have passed.
Lordship.
So you wish to pay it with interest, sir?
Lordship, your lordship, so far interest, your lordship, that will be a prayer before your lordship. So far,
you have to pay it with interest, sir, and submit proof of payment.
Lordship.
Despite nearly 3 years having been elapsed since the impugned order dated 6th February 2020 of the learned single judge, and despite there being no stay granted by this court in the present appeal, it appears that the present appellant is not complied with the directions of the learned single judge to pay the opposite party number 2.
But now 5 years.
Sorry, opposite party number 5. The sum of rupees 1,98,842 as directed. Full stop. In that view of the matter, full stop, the appellant did not even get the present appeal listed for hearing even once during these 3 years. Full stop. Paragraph. The court therefore would like the appellant in the first instance to comply with the direction issued by the learned single judge without prejudice to its rights and contentions in the present appeal. Full stop. Since the payment has been delayed by 3 years, court directs that the said amount of rupees 1,98,842 be paid to the opposite party number 5 within 4 weeks, together with simple interest at 6% per annum from the date of the order of the learned single judge up to the date of payment. So the proof of payment be placed on record before the next date. List on. 14th February.
Not only one
No,
submission.
sorry. 23rd. Sorry. 23rd February. 23rd February.
My lord, I'm sorry, my lord. For
Oh,
item number
one
40,
submission in that matter. My lords, I may kindly be permitted to place, let's say, one.
Kindly say, proceed, sir.
Your lordship's kind permission. My lords, we have already paid 1,57,000. That may kindly be adjusted, so with that we will pay the remaining amount.
Whatever you comply with the order, sir, that's all. We asked you to comply. I asked you clearly whether you've complied or not. You said no.
No, yes, lordship, we have not complied. Only thing is that, my lords, at page 11, I have taken a specific stand, lordship, that 7,000 employees will now they claim this revised scale of pay, which is not at all applicable. Only your lordship may kindly say this will not be treated as a precedent, lordship.
No. If you're not pressing the appeal, we can tell all that, sir.
Yes, lordship. Yes, I will not.
All right. Constable, the appellant states that they will comply with the order of the learned single judge.
Yes, lordship.
Provided the impugn order is not treated with the caveat that the impugn order should not be treated as a precedent. Full stop. It is clarified that the impugn order will be treated as having been passed in the facts and circumstances of the case and will not be treated as a precedent.
Highly grateful, lords.
Writ appeal is disposed of.
I may be excused, my lord. Item 40, my lord, at the time of call, I could not respond, my lord. My lord, it is also that similar Saurav Parida case. Item 40. Obliged.
Item 44.
My lords, with my lord's permission, may I appear virtually?
Yes, please.
My lords, these are three revision cases which have been filed by us for 3 assessment years, my lords. 1986-87, 87-88, and 1988-89. My lord, these pertain to central sales tax assessments.
Yes.
My lords, we are the manufacturers of iron and steel products in the state of Odisha manufacturing the products under Steel Authority of India Limited, my lords. And we are the Rourkela steel plant based in Rourkela. My lords, throughout India, we have 5 manufacturing plants under Steel Authority of India and more than 40 branch sales offices. My lords, we stock transfer our finished goods, which are various types of iron and steel items like plates, angles, channels, bars, etc., to our branch sales offices, from where these are ultimately sold to the customers. Therefore, my lords, when we transfer the goods from the state of Odisha, which is our manufacturing facility, to the branch sales offices, we do it under the cover of stock transfer notes along with Form F. Then we procure Form F from the receiving branch. My lords, we furnished all these particulars at the time of assessments. And now, in my lords, there are 3 years involved, as I said. In 2 years, the authority accepted our Form F and held that these are only branch transfers, not interstate sales. In the 3rd year, my lords, they raised a dispute in the assessment stage. And for the remaining 2 years, my lords, where they assessed it initially, they, by way of reassessment proceedings, they initiated and again challenged the Form F submitted by me on merits. So, my lords, in the 3 petitions, the issue on merits is identical. Whether the finished goods that I have supplied to my branch sales offices outside Odisha, whether it is a stock transfer or interstate sale, that is the issue. I am claiming them to be stock transfer. After stock transfer, my lords, whenever those goods have been sold from those respective branches to the ultimate customers, appropriate sales tax in the respective states have been paid by the branch sales offices. Now, state of Odisha says that these goods that have been supplied are interstate sales, therefore you pay CST to me. Therefore, my lords, on those same goods on which I have already paid sales tax in the respective states of branch sales offices, the state of Odisha wants to tax it here as interstate sale. My lords, this is the factual snapshot of the matter, my lords. I'll go into details of how the facts and how the sales were taken place, my lords. For this purpose, my lords, since there are 3 years involved, I would request, my lords, that the very first assessment year, that is 86-87, that records may be taken up, my lords.
Yes.
And my lords, that pertain to TREV 148
Yes.
of 2001.
Yes.
My lords, during this relevant period, my lords, iron and steel was an essential commodity under the Essential Commodities Act 1955.
Yes.
And its acquisition and disposal was governed by, my lords, Iron and Steel Control Order 1956.
Yes.
My lords, in terms of that control order, my lords, there was a joint plant committee which was set up by the ministry.
Yes.
In terms of that order, that was led by a chairman who used to be called Iron and Steel Controller, and other members of the committee used to be the representatives of various steel manufacturing units, which were the top steel manufacturing units in India. One of which was our unit, other was TISCO, and also Indian Steel Company. So all the joint plant committee used to be there, my lords. And as per the guidelines framed by Joint Plant Committee, my lords, where all the industry was divided into 4 categories: Category A, Category B, Category C, and Category D, who had to use the iron and steel. That means the purchasers of iron and steel were divided into 4 categories, my lords. Category A was the most priority core sectors like railways, defense, small scale industry corporation, electricity boards, etc. My lords, thereafter, category B, C, and D were less on priority as compared to A. So, as per the Joint Production Committee, Joint Plant Committee, my lords, the guidelines that they introduced, they said, for every year we will give priority to sector A first. So, all these industries who are there in sector A, they used to place their annual requirement to the Joint Plant Committee. Thereafter, my lord, Joint Plant Committee used to take what is the capacity of production, what is the production plan of each of the manufacturing unit of steel and iron and steel products. Thereafter, my lords, it used to issue allocation quotas to all these persons, to all these status A sectors, industries. On the basis of these quotas, my lords, allocations that they get from Joint Plant Committee, they used to give a requisition to the branch sale offices of Steel Authority of India Limited, my lords, which were there across India. So whatever whoever industry which is there in status A, it would give the requisition to its nearest branch sale office. Not these branch sale offices all over India would compile those and give it to their Central Production and Planning Department, which is called CPPD, my lords. Thereafter, my lords, CPPD, what will it do? It will again call for the quarterly production plans from the plants. And on that basis, since we have 5 manufacturing plants all over India, it would allocate that this much is your capacity, this is your production plan. So you produce this much of quantity and give it to respective branches, to the respective branches. So it used to prepare a dispatch plan also, my lords. On these basis, my lords, the consignments, the goods used to be manufactured and transferred to the branches, from where after the branches received the goods, my lords, these goods used to be, we used to give an offer letter to status A customer saying, as per your allocation, you had made this much of demand registration. So the goods are available. You may pick it up now after paying the price. After receiving an offer letter, the status A customer was at liberty whether to purchase it from us or not purchase, depending on its requirement. So at that time, my lords, a concluded contract entered agreement to sell used to be in place if it paid me the price and lifted the quantity. This was for customer.
What would be the rate of sales tax, sir? Is it any different? The intrastate sale that you make and the CST rate?
No, my lord.
Difference?
My lord, CST is at a lower rate because usually we get it for against Form C and Form D. The rate of tax used to be 4%, rather than local sales rates used to be a little higher on a higher side, my lords. There was there was no favorable rate to me at any point of time in any of the local sales.
No. See, the question really is this: from the time it leaves your factory,
yes,
and reaches that branch of yours in another state,
yes,
there is no transfer of title in the goods, correct?
Not at all, my lords.
No. So in that case, till it reaches the final customer there is no transfer of title.
Yes, my lords.
So one way of seeing this is that this is incidental. This branch transfer is incidental to the sale you make to the final customer. That's another way of seeing it, isn't it?
No, my lords, because as per my lords, section 3 of the CST Act, it says the sale would be deemed to be interstate sale, provided it occasions the movement of goods from one state to another.
Correct.
So therefore, my lords, a contract of sale has to be entered prior to, so as to say that there is a movement of goods. Now, in my case, my lords, I'm only taking the requirements on a quarterly or an annual basis as to what is the requirement of every customer, so that I can plan my operations. Because, my lord, during that period, iron and steel production in India was not sufficient to meet the entire industry. Therefore, I wanted to give priority to some sectors.
No. See, your submission will be right if the seller is your branch office and not you.
My lord, seller is my branch office only.
No. Your branch office doesn't have any title to transfer. See, your branch office is your extension, right?
My lords, in every case, the branch office is the extension of the.
That's right. So you are the seller. There's no separate entity. The branch office is not a separate entity.
My lords, these customers, they approach branch.
It's only when the customer buys is the contract concluded.
Yes, and the customer approaches branches only.
So till then, the goods are only moving in pursuance of that contract.
No, my lord, there is no contract. That is what, my lord, the contract arises only when I have, because my lord, these are the standard goods that I have. And when goods leave the factory, it does not leave for a particular customer. It leaves for a whole lot of industries, etc.
Correct.
In bulk railways. And all these goods are unloaded. I maintain a stock, regular stock in my branches. And even, my lords, there are walk-in customers also. For who have not given
this must be a settled position in law. There must be case law on this.
There are a number of judgments, my lord.
Just give us some of the judgments.
Yes, my lord.
Just give us some judgment.
Yes, my lords.
Pick up your best judgment and the most recent judgment. Let's read that.
Yes, my lords. My lords, the compilation of 151 pages is there with my lords.
Let's look at the most recent Supreme Court judgment. There must be a Supreme Court judgment.
My lord, the Supreme Court judgments I have put are the landmark judgments. Vallabhdas Gulastan, Telco. My lord, Telco is the most relevant to our facts of the case.
All right, let's read that. 66, is it?
Yes, my lord, 66.
All right, let's read that.
I'll just briefly explain the facts which were there in this 66.
Yes.
My lords, just like in our case, there was this iron and steel control order. During the relevant time, there was Commercial Vehicles Control Order 1963. As per this control order, my lords, here, my lords, Telco was again into the manufacturing of heavy equipment vehicles and supplying it to their dealers through the network of their branches. Now, my lords, Telco had their factory in the state of Bihar, but their branch sales offices were there across India. So, my lords, as per this control order in 1963, what it said, every dealer needs to submit to the manufacturer various statements as to how many applications they have received for further sale, how many have been cancelled, how many sales have concluded during the particular month, and how many orders have been executed, how many orders are pending. Depending on this, my lords, there used to be an estimation as to what is the requirement of stock at each dealer's end across India. My lords, agreement of Tata with its dealers obligated the dealers to place the firm orders 1 month in advance and also give an estimation for next 2 months. Basis these estimations, etc., my lords, though Telco in this case submitted on facts that there were no firm orders anytime received, but yes, all these statements were there, and on the basis of these statements, an estimation was done, and their sales team used to allocate the vehicles to the respective branch sales offices from where they are sold to the dealers. Here again, the state of Bihar said, whatever you are doing is pursuant to these estimations, etc., and for ultimate supply to the dealers in the respective states. Therefore, this movement from the state of Bihar to your branch sales offices qualifies as interstate sale and not the sales by the branch offices to the respective dealers. That is what this was the contention of the department, my lords. The findings, my lords, start here.
I think if you just read 11 and 12, that's more than enough for you.
Yes, my lords.
Para 11 and 12.
Yes, my lord. My lord, may I read 11? In the communication which has been referred to before sent to the Assistant Commissioner, it has been emphasized that although the above clause regarding the firm order was included in the dealership agreement, in fact, no firm orders were called for view in view of the control order. It was maintained that during the relevant period, sales were effected from stockyards alone. Procedure adopted being as follows: the sales office of the appellant in Bombay, after taking into account the production schedule requirements of individual states, the government directives and other relevant factors, instructed the factory at Jamshedpur to transfer stocks of vehicles to the stockyards in various states. The instructions for transfer were given by the sales office by stock transfer authorization, in which the model of the chassis and the number of units were mentioned, along with the name of stockyard to which the same were to be transferred. Pursuant to the stock transfer authorization, the works prepared a stock transfer memo, which indicated the quantity of the vehicles to be transferred to the stockyard specified in the memo. This memo was signed by the transport contractor appointed by the appellant for transportation of the vehicles to the stockyard. On receipt of the vehicles at the stockyard, any deficiency in or damage to the vehicles was noted by the stockyard in charge. Unless damage to the vehicle was set right, they were not appropriate to any contract of sale. The stocks available in the stockyards were distributed from time to time to the dealers, taking care to ensure that the overall supply of dealers in any state would be in proportion to the number of orders pending with the dealer on 1st May 63 or on the basis of offtake by the dealer during the year ending September 30th, 1962, as required by the control order. For this purpose, allotments were made to the dealer for each month by an allocation letter by the sales office. It is claimed that the transfer of vehicles from works to various stockyards was a continuous process and was now not related to the requirement of any particular customer, whether a dealer or a corporation or a private individual. These vehicles were transferred by way of stock to the stockyard or depots from where the transaction of sale were affected. It was pointed out that there was no connection between the stock transfer authorization and the allocation letter. The vehicles were delivered to the dealers as and when they were available in the stockyards, irrespective of whether or not allocation for the dealers had been made or notified to them. There had been many instances where the vehicles had been actually delivered from the stockyards prior to the issue of the allocation letter. The vehicles delivered to the dealer from the stockyard were accounted for against the allocation over the period. It was the stockyard in charge who appropriated the required number of vehicles to the contract of sale out of the stocks available.
All right. We'll just ask the department counsel. Yes.
My lords.
My lord, I will just place, my lord, the finding of the assessing authority from TRB number 148 2001. Paper book page 30.
What's the date of this order, sir? What is the date of this order?
That is 4 January 1993.
Does it consider this telco case, sir?
No, my lord.
So what do you have to say on the telco case itself?
My lord, then I need some time, my lord.
No. We're not adjourning it, sir. Sorry. We're not adjourning it. This has been adjourned several times.
There he has transferred the vehicles, my lord.
That's all. There's no identified buyer, sir.
Yes.
The branch, then they come to the branch and then buy it from there. So the law, as explained by the Supreme Court, is the movement of the goods has been to be pursuant to a concluded contract. There's no concluded contract pursuant to which the goods are moving.
My lord.
Questions of law already been framed?
Yes, my lords. My lords, two questions of law were framed when the matter was referred by the Honorable Tribunal for revision to this, for reference to this court.
All right. So we allow these revision petitions.
My lord, other sale matters has been posted to. Sale matters has been posted to 23rd February of this. February 23rd.
If you are agreeable, we'll take it on board today itself and finish it off.
Similar matters are there, my lord.
No, so we'll take it on board today if you are agreeable. By special notice, we can take it up today. So,
there we have
different assessment years, no?
There we have filed written notes, my lord. There we have filed written notes, my lord. So it will be easier for us to.
Which is that matter?
The number is not there, but 23rd February that has been posted to.
My notice, there is nothing. These are the three matters only which are pending for seal authority.
Other similar sale matters, my lord, which has been returned back from the apex court, my lord.
No, these three matters only. I don't think there is any other matter. Give us some number at least, sir. You can't simply say there are other matters.
No, Lordship, those other matters are not identical, your lordship.
Ah,
In those
different.
other three matters, your lordship, that remanded by Honorable Supreme Court on those three issues, your lordship.
That's nothing to do with
This
this.
case, your lordship, some latest judgments have come on of Honorable Supreme Court. Your lordship, at least
Which are contrary to this.
not particularly contrary. That pre-exist, so far as that pre-existing contract, the branch transfer is pursuant to those pre-existing contracts.
That's right. If there is,
and Honorable Supreme Court has clearly held that each and every transaction is to be verified, your lordship. Your lordship, in all the judgments, subsequent judgment, your lordship, just your lordship, 1 week time may be granted for only for clarification of that issue, that pre-existing contract.
Here there is nothing factual. You point out here also factually that there is some pre-existing contract.
Whether, your lordship, only issue whether
No, we can right now do it because this is not a recent assessment. This is 86, 87.
Your lordship.
There's enough papers with you. You
also-
carefully go through the paper one by one.
Your lordship. Also,
We can, if you want, we can pass it over.
Your lordship,
We're not adjourning it, sir. Because these are 2001 matter, we're not adjourning. 100% we are not adjourning. If you want time to sit down and study one page after the other, you do it. We'll pass it over.
Your lordship.
Pass over.
Your lordship.
Item number 45.
45 in my player. Lordship, kindly have that order dated 5/7/2022. In that order, Lordship have asked for a paragraph 4. The Tahsildar Bhubaneswar is directed himself to visit the land visit the site in questions and ascertain as to whether in fact the petitioner continue to cultivate the land in question and
What's the position, Mr.
Yes,
Mantika?
madam. Let's Lordship kindly have, they have filed the report. Already filed along with the affidavit of the affidavit. Kindly have that affidavit, your Lordship.
Yes.
At page 3 of that affidavit. I'm reading, my lord. The second paragraph, 1, 2, 3, 4, 5 line from the bottom, second paragraph. No, you start from the beginning. That is otherwise. I just put it in this way. The possession and the cultivation both have been found in favor of the petitioner.
No.
With
That
some
I will
opinion.
submit.
No, let my lords kindly. The report is there. After proper verification of the record and village map, it is found that the suit land in question is well coming within the AIMS campus and no access to this plot is available to a nearby public road. Further, the suit land is found lying open without any boundary around it, but there exists a small house of brick wall with adjusted roof and another mud wall with thatched roof, which appears to have been recently constructed in order to prove his possession. I have filed my rejoinder in 2013 and there I have annexed those two photographs. Allow me. Next. So my possession. The next is no electricity and water connection. Admittedly, it is not there. The petitioner present during the inquiry stated that he has been staying here alone, where his family member are residing in the native village. But the AIMS authority and local people are of the view that most of the time house remain locked. The petitioner occasionally comes to the house in the daytime. So my possession is there, my lord, with his opinion. The second is cultivation, my lord. Kindly have. As regard to the cultivation, it is noticed that some vegetable seedings has been planted recently. Now, my lord, again, that is also there, and he being a opposite party number 3 with his opinion. Now, my lord, what is the issue here? The issue is 7A3 order has been challenged. Lordship may kindly have that on.
My lord,
And
I may be permitted to place the entire report because
No, let him finish and then you can please.
Yes.
If we are with him, we'll call upon him.
Yes.
All right.
My lord, kindly have their counter affidavit. I will not go to anywhere else. My lord. The entire counter affidavit is not premised with any fraud. Your lordship kindly have internal page 3, page 15. They are now citing what are the irregularity maximum. I can use that irregularity has been committed. Inquiry has not been solved properly by the Tahsildar as required under Rule 5.5 of the Odisha Government Land Settlement Act. Your lordship can have that 5.5, Rule 5.5.
So you have nothing to say on the report that has been now submitted.
The report, they have my possession.
We will proceed on the basis that you have no objection to this report.
No, they have said that I will file an objection. But the objection,
objection now. Sorry, you've had this report with you for quite some time. Now,
in the last week only it is filed.
No.
Even last occasion, the report has not been submitted to your lordship. Pursuant to your lordship direction, 2 days, 3 days back.
No, it was filed.
This is not such a complicated report.
There are 2 questions your lordship has asked them, that whether I'm in possession and whether I'm in cultivating possession. Please, lordship, I am again drawing your lordship attention. The possession with my house has been said.
that the house is there and this house is mine, and they have not furnished the photograph. I filed my rejoinder way back along with the photograph of my house. So this is again that thatched house and asbestos house photograph is there along within the rejoinder affidavit I filed much prior to this. Now, insofar as the second cultivating, they have found there is a cultivation. Now
have they?
Yes, my lord. Kindly let's see. They have. As regard to cultivation, it is noticed that some vegetable seedling has been planted, but the word is recently is opinion. My lord, he found there is a cultivation.
Sir, Ratha, we've been lawyers at the bar. Unfortunately for you, we know what it is to read 2 lines of a sentence and leave out the rest of the sentence.
My lord, I'll read.
If you think it is advantageous to you, you proceed.
No, my lord, I will read the entire.
As far as we are concerned, we'll read the whole sentence.
My lord, I will read.
You read whatever you want to read.
As regard to
but we both will read the entire sentence.
My lord, I will let me press please. As regard to the cultivation, it is noticed that some vegetable seeding has been planted recently in small patches within this plot. No source of water facilities available to grow vegetable crops, and thus the land is not amenable for cultivation. My lord, with due respect, I am saying that your lordship has not opined whether it is occult. From local inquiry, it is gathered that no cultivation is seen in this land for past years. No persons have been signed. So, it is clear under the circumstances. But this is what the 2 questions. Now, my lord, I am proceeding to that order itself, impugned order. Why I am here, and your lordship have granted me status quo order since 20th February 2013. Lords, may I just place, my lord? Let's kindly have that rule 5.5.
Yes, please.
The proclamation shall be published with beat of drum and by affixing a copy of the same at conspicuous places of the village or urban area in which the land is situated in presence of not less than 2 persons of the locality. If the village is uninhabited, the notice shall be published in the nearest inhabited village. A copy of the proclamation shall be published by affixing in the notice board of the Tahsil land. Now, my lord, see, this is the first violation or irregularity has been found. Now, please see their own record. They have annexed, my lord. That is at page 26, my lord. The lease number is, I beg apology, my lord, this is in Odia. The lease, my lord, kindly see the case number is 774. This is a 1 month notice, my lord. And the next phase is signed by 4 villagers, not less than 2 villagers. This has been served on 4 villagers. And this is the notice dated way back in while considering, my lord. So, and there is a report of the persons who are taking. So, my lord, the first ground, which is there in the impugned order, is belied by their own document, which they have annexed to it. This notice has been served in the village and more than 2 persons has been signed it. My lord, the next point is the proclamation objection, my lord, objection invited here in this notice itself. May I, if I place it in Odia, Sri, my lord, in Odia, may I permit it, please? Sri Hulas Vera Pita so and so Nimnolikhita Brutiku Sarkaranga Tharu lease neba pai darkhasta kari in just in I can translate it. The petitioner has applied for lease of this land, and if anybody has any objection, then they have to make it within 30 days up from the day notice by submitting appropriate application, paying court fee. This complies 5.5. Now the second ground, my lord, first and second ground is relating to 5.5. The third ground, your lordship can return to page 15 again. That is, the settlement is made without observance of the provisions of 3.2 of the Act. Lordship may kindly have that 3.2 of the Act. Section 3(2). In settlement of land under clause E, the subsection 1, 70% of thereof shall be settled with a person belonging to scheduled tribe and scheduled caste in proportion to the respective population in the village in which the land is situated and remaining. So, my lord, here in the case, the petitioner is a landless scheduled caste person. So, again, 3(2) says that at least 70% has to be settled in favor of scheduled caste and scheduled tribe. I am a scheduled caste person, and I am still residing. This is very few genuine cases where even 74 lease I am continuing to there. So this 3(2), there is absolutely no violation, as I am a landless person and a scheduled caste person. At the time of grant, I am a landless person and I am a scheduled caste person.
What does the report say, sir, on your landlessness?
My lord, the report says that in 1981, admittedly in my rejoinder, I have annexed those documents. In 1981, I purchased that 48 decimil of land. The lease granted in 1974. So the 48 decimil of
today, once you have another piece of land, today in 2023, we're not going to legitimize your...
No, my lord, no question of legitimizing, my lord. At the scheme of the acts advises that whether I am a landless agricultural person or not.
This is meant for that, sir. Not for people like you.
No,
for people like you.
Yes. This lease,
this is not meant for people who have another piece of land.
No, my lord, I was never having.
No,
I have.
You now have. You're not even disputing.
My lord, no, I am also saying that I have procured it.
The whole purpose of all this was something else, sir.
No, my lord.
This has all become commercial. This is the heart of Bhubaneswar.
Exactly, my lord.
Yes,
For last 50 years, I have been using.
Absolutely. You've enjoyed enough, sir.
No, my lord.
Enjoyed enough.
Your lordship's own order. I have,
yes.
I have that.
What must be the value of this plot now?
My lord, it is within the campus of the AIMS. Within the campus.
My lord,
there is no access to the road.
No,
it is totally within the campus of the AIMS. It is now under the position.
My lord, there are several other persons have been getting. AIMS comes later on. Your lordship kindly.
AIMS, recently we have alienated this land.
Alienated because
in favor of AIMS.
No, during continuation of the stay order.
Stands recorded in favor of government. Then we have alienated. How can it be a private land inside the AIMS campus?
You have leased it, and during continuation of the
that lease was cancelled. Thereafter, the
was corrected. Paragraph 16 of the report.
ROR was corrected in favor of the government.
Lordship, kindly have that 16. The ADM appears to have invoked 7A3 of OGLS Act on Ethiki, that is 19 years after the applications made by the petitioner and 14 years after the lease has been settled in favor of the petitioner. When summatory proceeding were
now para 16, if you read this judgment, there was no material on the basis of which one could conclude that the lease was improperly granted. Here we have a whole report of the collector, sir.
No, not collector of
Tahsildar.
Yes. The lease was not cancelled that I have committed any fraud. Kindly look at this way. I have my representation. Again, another judgment of our own High Court and the same line. The Lordship can see that. It's a coordinate win.
All right.
The separate view of Justice Aji then was at paragraph 10.
Yes.
It is well settled that before exercising the power or jurisdiction vested in an authority, he is to satisfy himself about the existence of circumstances necessitating exercise of the said jurisdiction and to record a prima facie reason for the same. Mechanical reproductions of the language of the statute in the order or notice is no substitution of recording of reason upon the applications of mind to the fact and circumstances. No fishing. No, my lord, here also the kindly look at the impugned order. Absolutely no allegations that I have ever even misrepresented a fact. And that is also not there. I was not continuing in possession. At the time of passing the order, or not even today, I am not in possession of the property is not there in the record. And that is not also there in their counter affidavit. No. And lots of again, that is absolutely, and 7A3, my lord, the condition is 7A3, my lord, that is also. Notwithstanding, may I just please, notwithstanding anything contained in this act or any other law, the collector may on his own motion or otherwise call for or examine the records of the proceeding in which the authority subordinate to him has passed an order under the Act for the purpose of satisfying himself that any such order was not passed under mistake of fact owing to fraud or misrepresentation under or on account of material irregularity of the procedure or passed. My lord, I just asked myself, there is absolutely no material irregularity. I have demonstrated that rule 5.5 has been complied and it is their admitted document. Now the material irregularity number 2 is the violation of section 3.2. I demonstrate that I am a scheduled caste landlord person. So there is absolutely no violation of section 3.2. So there is no material irregularity. Now in coming to the case of fraud, my lord, nothing they have annexed my lease application. Nothing I have stated in my lease application which is a misrepresentation or a fraud. Nothing, my lord. And therefore they have never even in their counter stated that. So, there is no material irregularity and there is absolutely no misrepresentation. These are 2 points, my lord. And the total counter affidavit is based on these irregularities, 5 numbers of irregularity, which I stated on the basis of the Act itself, there is absolutely no irregularity. And again, your lordship's own order is that there is.
Yes, Mr. Monti.
And I am a landless person.
My lord, I may supply your lordship actually, the original record is also with me. The present status the Tahsildar has reported, this land, 200 decimal of land, is within the AIMS campus. And recently he has made certain unauthorized construction, mod house, and without any electrification. He is the owner of 48 decimal of land. That also it is admitted. And in the impugned order, the ADM has noted that what are the material irregular. And not only in this case, there are several cases where the ADM has invoked 7A3 and cancelled the lease in view of the fact that these original lease were either it is owing to fraud or misrepresentation or due to material irregularity in the procedure. So I pray before your lordship that there is no ground to interfere with the order of the ADM. And this is a government land already recorded in favor of the government. Pota has already been published and it is alienated in favor of the AIMS. AIMS is in occupation of the land. It is within the campus of the AIMS. So at this stage, if any order is passed in favor of the OP petitioner, then irreparable damage will be caused to because the OMC is now in possession of the land.
No, alienation is pursuant while continuation of the status quo. And therefore, this land was always kept out of that alienation. And even AIMS have, themselves have given, and have given that photograph and demonstrated it. And while continuing, then since 2013, the status quo is continuing, and during continuation, the alienation. So that's a subsequent event. Now, the material, the impugned order which forms the basis for depriving me from my title is to be seen, look into, my lord.
Dismissed, I'll pass the detail. All these orders and that's direct. Make sure it comes.
Item 46. 46, my lord. This honorable court has on 27th October 2014 has framed the question, my lord, whether on the facts and in the circumstances of the case, in absence of notification of central government in consultation with board as required under section 3B Roman 4, read with section 3AA of section 5 of the Drugs and Cosmetic Act 1940, the commodities such as parallels, SHT tubes, VST tubes.
What's the tax effect, sir? What is the tax effect?
This one has 1 lakh some odd and the next one is 4 lakh some odd.
No, the demand is
within the scope of entry 37, schedule of goods subject to levy of sales tax under the Orissa Sales Tax Act 1947.
No, the demand in the first
page 6.
First case it is 95,000.
My lord, page 6 of my revision petition, I have called out the entry, my lord, entry 37. Drugs as defined in clause B of section 3, 6% of the drugs and 1940 Act 040 and Ayurvedic Homeopathic and Unani medicine,
The names of the
6%.
opposite party is not reflected, sir.
Mukesh Agrawal.
You see the names of the council, the opposite parties be reflected in the council list by the registry. List on. Second May.
Item 47. My lord has already answered against the revenue, my lord.
In view of the order passed by this court on 7th December 2021, in writ petition civil 10424 of 2014 bracket, Messrs. Bhubaneswar Club Bhubaneswar versus Commissioner Cultural Services. The revision petition is dismissed.
Item 48. 48 also answered against us, my lord.
In view of the order passed this court on 6th July 2022. In STRV 25 2013, Sun Pharmaceutical Industries with State of Orissa, the present revision petition is dismissed.
Item 49.
In item 49, I'm appearing through VC, my lord. My lord, this matter has become infructuous.
All right, dismissed as infructuous.
Appearance of you never noted.
Interim order is
Another 2 matters then there. I can personally sleep, then if you influence, then it can be disposed of.
My lord, may I humbly submit, my lord? My lord, what has happened is in this case is this: we have challenged the notification of the notification passed by the Director General of Foreign Trade. Now, this notification was dismissed. This notification was quashed by the Calcutta High Court, my lord. My lord, I will provide you the judgment. My clerk will provide you the compilation of the judgment, and this the quashing of the order was also challenged by the Union of India before the Honorable Apex Court, where that has been issued notice and no interim order has been passed.
So you made a submission that the petition has become infructuous.
Yes.
You've already disposed it off as infructuous.
Right, my lord. My lord, I'm just informing the court because it is my responsibility that what has happened behind the matter. That is all. This is.
I don't understand. Are you standing by your submission that it has become infructuous?
Yes, madam.
That is all, sir. That is all. What is the other two matters?
I'm just separate noted there is. Apart from this number, there another 2 number is there.
No, but those, how do you know counsel is the same in those matters?
Councils are same.
Counsel are same.
Mr. Bhutta checked out, but councils are same.
You are also appearing in 11451, sir, and 453?
No, my lords. I'm appearing for this single case.
Or Lakshmi list tomorrow or day after.
All right. This is day after 11451 and 1453. All right.
For 1, 2, 3 were there. For 4, Mr.
4 Millard
is appearing for customs.
All right.
Much obliged.
Item number 50.
My lord, I am appearing in this case 2695.
Lakshmi, along with me, Mr. Bhutta appearing his name.
All right.
On account of my illness, my lord, the throat infection and fever, I pray for a short adjournment, my lord.
All right. Counsel, the petitioner is stated to be unwell. List on 21st August. We'll continue after lunch.
21st of
Shall I?
Yes, yes. Come.
Item number 54.
Your Lordship, so far as the law is concerned, Your Lordship. So far as the law is concerned, Your Lordship is absolutely right, the judgment. But here, Your Lordship, so far as the facts are concerned, Your Lordship, so as regards to the facts are somehow different, Your Lordship. Your Lordship, as per the judgment of Honorable Supreme Court, different judgments are also enclosed here. Each and every judgment says that each and every transaction is have to be verified. And some of the transactions have been verified by the law and assessing officer in course of assessment. But Your Lordship, during the course of assessment, as well as the first appeal, as well as the before tribunal, the petitioner has not cooperated, has not produced any of the documents. For that reason, Your Lordship, this finding has arose. And tribunal also, in its order itself, tribunal says that tribunal is constrained to pass the order. Tribunal said the matter has been set aside to the assessing officer for factual verification. Even in the set aside proceeding, the assessee could not cooperate. Your Lordship, may kindly turn to the assessment order. This is the paper book, Your Lordship, in PREP number 148, 2001. That is 1986-87. Your Lordship, that assessment order, Your Lordship, operative portion is at page 80. It starts at page 80, how the petitioner has not cooperated, Your Lordship. There was no response, Your Lordship, got it?
One minute. Page 80, right?
Page 80 of the paper book, Your Lordship. The assessment order, Your Lordship.
Page 80, something else. 1 minute.
Which paper book?
148. There is
one. PREP one.
The page numbers on the left or the right?
Your Lordship, at the right corner, Your Lordship. Page internal page 15 of the assessment order. Running page 80.
That's not
No, there is mismatch between your paper book and that. We don't have the order.
Assessment order, assessment year 86, 87, 31st, 10th, 88.
Assessment order.
This, Your Lordship, before going to the merit of the Your Lordship, the issue of the case is that, Your Lordship, now this particular issue is pending.
Pending where?
Your Lordship, pending before Central Appellate Tribunal in the subsequent year. This time bound scheme, this everything, this order is also.
Okay, but anyway, they'll follow what we decide.
Your Lordship, page 15. There was no response to the above intimation for which the Assistant Commissioner Sundargarh Range Raurkela issued a subsequent letter so and so and required 3 months time for so and so, so and so. Now, Your Lordship, can kindly turn to page 81. From the information available in the investigation report, it is noticed that RSP dispatched steel material by rail in the name of some customers and intended goods direct to the steel plant. The goods were booked in the railways and corresponding RRS and other documents were prepared in the name of intending buyers. Therefore, movement of the goods occasioned from the state of Odisha to outside of the state on a prior contract of sale, but it was not known from some mysterious reason the said materials were stated to have been taken delivery by the branch sales office, sale New Delhi, and subsequently delivered the same goods to the intending parties, showing the transaction as a transfer of stock from RSP to the stockyard of sale at New Delhi. This is colorable device by the dealer company to treat interstate sale as interstate sale, section 3 of CST and section 6. Now, Your Lordship, some of the examples, Your Lordship, some of the transactions.
But I'm just trying to understand this 4% CST you're collecting at this end.
Your Lordship.
He has already paid local sales tax at the point of sale there, wherever he has sold it.
Your Lordship, it is not the dispute.
I mean, he has collected.
Your Lordship,
not there it's that's what I'm trying to tell you.
Your Lordship, it is not the dispute between interstate sale or intrastate sale. It is the dispute between interstate sale as well as branch transfer. Same CST. That judgment, so far as the Ashok Leyland case, your Lordship has seen, in that judgment.
No, we're not seen Ashok Leyland. We saw Telco. Page 66.
Telco, yes, that Telco judgment, even the Telco judgment itself says that each and every transactions have to be verified.
You tell us which transaction here is pursuant to an order booked, pre-booked.
Your Lordship, may kindly turn to internal page 18, Your Lordship.
18.
Your Lordship. From the information, page 18, internal page 18 of the assessment order. Your Lordship, shall I please, Your Lordship?
This assessment order is not there.
This is my lord, reassessment order.
But this is not the standard.
Mr. Ponda has replied these assessment orders. Other orders, appeal orders and.
Yes, I have.
First appeal order and second appeal order original. A reference order is there with us.
Lordship, I don't have those orders.
Anyway, which year are you referring to? 86-87?
86-87.
Internal page?
Internal page 18, Your Lordship, of the reassessment order.
My lord, may I clarify one small point?
Under Rule 10 of the.
My lord, may I clarify one small point?
Yes.
My lord, I think what my local advocate has given you are the original assessment orders. But what my learned friend is referring to here are the reassessment orders, my lords.
Right.
So the reassessment orders is at paper book 1, my lords, page 83, as my learned friend is rightly referring. So those reassessment orders need to be, I think, what he is arguing from.
Page 83
of the paper book 1.
Page 83. Yes.
Our pages are somehow not tallying. That page 83 of our paper book is some other document. In fact, we've got paper book 11, paper book 2, I think. This is paper book 2.
Paper book 1, please refer to my lords. It is reassessment order dated 31st October 1988. My lords, there was one more small legal issue involved, that prior to 2010, the jurisdiction was not there with the authority assessing officer to pass reassessment orders. That is settled by Ashok Leyland case, which is part of my compilation, my lords. And they brought in an amendment in 2010 to give those powers of reassessment to him. So the reassessment orders are per se bad.
As per the original assessment order, then what happens?
My lords, original assessment order is there with my lords. At page 10, he has accepted all my form F and said, I have made the inquiries, seen all the records, dispatch statements, and form F is allowed. That is the finding in original assessment order.
Have you taken this point in the present revision petitions?
Yes, my lords. Yes, my lords.
But question was not framed on that.
Question, my lords, because that time Ashok Leland case was not there initially, and it came on later on. Therefore, we filed the applications for addition of questions of references. But please check the reassessment proceedings, my lords.
You've raised that in that application.
In the applications we have raised, yes, my lords.
Which application is that?
My lords, that again TREV, this 148 itself. We are challenging the point on reassessment proceeding also, as well as on merits. My lords, this honorable tribunal, when they passed the order, I referred to this telco case before them, and they have given observation also on that telco case.
So question F is whether in the facts and circumstances the tribunal was justified in holding that the reopening of the assessment was valid. That's right. You've also raised a question of jurisdiction of the officer to reopen the assessment.
Your Lordship. Your Lordship, Ashok Leland case clearly said, my lords, prior to 2010, they did not have a jurisdiction.
What do you say to that? That's a very fundamental point, goes to the root of the whole matter.
Your Lordship, that question has not been admitted, Your Lordship.
No, they have filed an application.
No, Your Lordship, that question, Your Lordship.
Because that judgment was not available at the time the tribunal made the reference.
Your Lordship, it is a reference application.
That's right. So at that time, this judgment is not available. The judgment in Ashok Leland.
2004 judgment, my lords.
Once you have accepted. Your Lordship, actually.
There's an Ashok Leland Supra. For reopening assessment.
Your Lordship.
No, what do you have to say on that? Reopening of assessment.
Your Lordship, that part, Your Lordship, on the, as far as the merit of the case, your reopening. Your Lordship,
which paragraph of Ashok Leland, please?
My lords, para 44 onwards, 43, 44. My lords, page number 36 of my compilation.
Yes.
May I read, my lords?
Right. So 49, 50.
Conclusive presumption, and my lords, they finally conclude. Para 113, they finally conclude, my lords. Para 113, 1 to 115 is the final conclusion.
Right. Can be the subject matter of was not correct.
Because my lords, in 1997, Ashok Leland only, they held that it can be reopened. So here they said, no, that was an incorrect view by the bench at that point of time.
Right. All right. 114.
My lord is on mute. I'm not able to hear my lords. I'm sorry.
Correct. But what happened here is, so far as the assessment order is concerned, before the assessing officer, as well as before the appellate authority and tribunal, the assessee has not.
Unless you have material to show it did pass pursuant to a concluded contract, why should you doubt this F form being?
Your Lordship, I may be permitted to just your Lordship's attention that that page 83, some of the contracts, your Lordship, some of the examples, your Lordship, from where it can be presumed that there is.
Why should it be presumed? That's the whole point.
Your Lordship, may kindly look into the adverse report, your Lordship, from the information. Shall I place, your Lordship? From the information and material available in the assessment record and investigation report, it is seen that Messrs. Haryana State Small Industries and Export Corporation Limited had registered its demand with the branch manager, branch sales office, Faridabad, for supply of steel material required by it for the quarter April-June 86. In its letter dated so-and-so 24th March 86. The demand was registered as per JPC's allocation of steel materials. Requirement of MS steel, MR, CR sheet, GP sheet, CS sheet, different for supply with the branch manager Faridabad, which are exclusive product manufactured by RSP. So similarly, as per JPC's allocation communicated by its letter 22nd 586 of the Iron and Steel Controller of Calcutta, Haryana, Tata Steel Industries Export Corporation Limited, in their letter number so-and-so registered their demand with the branch manager. Branch sales office Faridabad. There must be similar such demand for the carrier October, December, and January, March. Branch manager, branch sales office Faridabad, which were not produced by the branch manager before the investigating staff, nor those were produced before me, a representative of RSP. Small scale industry is state, and similar circumstances. So my respectful submission and also the assessing officers finding at that.
If you have no answer to this reassessment, then we'll close it at that. All these questions you argue for the subsequent years. These revision petitions we decide on the basis, because one is 86-87, one is 87-88, the other is 87-88-89. These three we decide on the ground of reassessment and be done with it.
I may clarify, my lords.
Yes.
This reassessment point is there in 2 years, 86-87 and 87-88. Not in all my humble this thing. I should be fair to the court.
No, but for 88-89 also there could not have been a reassessment.
But they in original assessment only, in the main assessment only, they rejected these formats.
So for 88-89.
Yeah, we have to argue on merits for 88-89. There is no doubt.
So in 88-89 on merits, I think his attempt is to say that it should be sent back to the tribunal.
No, my lords, that cannot be at this stage, my lords. Because, my lords, I have all my documents. I can show you from the record also, my lords, as to how the demands are registered. Merely because, my lords, demands are registered, that doesn't mean that a concluded contract comes into it.
That's right.
And it is, my lord, these are not just the facade branches. These branches are maintaining regular stocks. People are coming and buying on a regular basis. These are standard goods. It is not that these are tailor-made goods also. What they were relying on judgments, my lords, were servicing, etc., which were tailor-made goods.
Okay.
So those judgments cannot be relied upon in my case, my lords. These are all standard goods, steel, iron and steel items of various specifications, which are standardly available in the market. And my lords, my demand registration form itself contains a clause that this does not guarantee supply. My lord may see one demand registration form if my lords are willing to see that. My lords may please come to paper book 2, my lords.
That's what we had. We have paper book 2.
Paper book 2. 1 minute. Lords, please turn to page number 96-97 of paper book 2.
Yes.
My lord, this is the demand registration form.
Pro forma.
Yes, my lords. Pro forma for registration of demand with concerned branch sale offices or main producers. My lords, please come to the next page. Clause 5, my lords.
Yes. It will not be construed to mean any commitment.
Yes, my lords.
So this is not a firm concluded contract.
Yes, my lords.
In fact, all the documents are already there on record.
Your Lordship, so far as the reassessment is concerned, Your Lordship, without considering, Your Lordship may consider that reassessment.
No, but anyway, for the third year, we have to go on merits.
Your Lordship, so far as the original assessment is concerned, Your Lordship. So because why I'm saying let it go, because Your Lordship, on the same issue, Your Lordship, on the same issue, same scheme, everything same, Your Lordship. The subsequent year, it has been decided, it has been set aside by the Central Appellate Tribunal to the tribunal by saying that each and every transaction.
Let them examine that.
Exactly, Your Lordship.
So we need not wait for that.
No, Your Lordship.
Here, since all the documents are on record, he's able to point out from the documents that there is no concluded contract.
In that 8889, Your Lordship.
That's right. In the 8889, he's pointing out the pro forma. There's no concluded contract.
The same scheme, Your Lordship.
Then this will be followed by the tribunal. Our judgment will be followed. If all these documents are identical for those years as well, our judgment will be followed. If those documents for those years are different, then they will come to a different conclusion. We can't adjourn saying that the tribunal has to decide.
I'm not praying that, Your Lordship. What I'm praying that originally, so far as that original, Your Lordship, maybe set aside to the tribunal.
Not
that
necessarily.
Original.
No, certainly not.
So far as the facts are concerned, that each transaction are to be verified. Also, Honorable Supreme Court is clear by saying that each and every transaction are to be verified, Your Lordship, in that Tata locomotive ray itself, Your Lordship.
Correct.
So, Your Lordship, here, prima facie in all the proceedings, Your Lordship, nothing has been verified due to either lack of, and also the petition has not cooperated in all the proceedings, Your Lordship. Your Lordship, prima facie on the face of these orders, Your Lordship. And if the petitioners could have produced and submit all these documents before the assessing officer, then the assessing officer as well as the tribunal could have obtained the finding, clear-cut finding that these are not interstate sale and transfer.
Where are the papers?
There are three schemes involved, my lords, identical schemes, status A, demand registration and time-bound supply scheme. My lords may please refer to all those three schemes.
Only one paragraph from that sister Central Appellate Tribunal order at page 137. You will see the same scheme so are there. Same scheme, same sale. This petition of this petitioner, you will see.
Sorry?
137, page 137 of that Central Appellate Tribunal's order that reported in 30 VST, 334. The same scheme, you will see. If may kindly look into that page, you will see.
Yes.
The center of judgment.
Conclusion at para 18, page 150. Conclusion is there. Tribunal's conclusion.
Para 18.
Para 18 is the conclusion, my lords, for this time-bound scheme which was there before the Honorable Tribunal in that matter.
Yes. But this goes against you, sir. Para 18.
And they, my lords, they discuss one transaction also in detail and say that whatever documents have been analyzed, those also are against them in this very same order. My lords, para 15, 16, they discuss one case in detail, para 15 and 16, and they say that they are not able to prove anything.
And your lordship, consequent to this order of the Central Appellate Tribunal, Learning Tribunal, the matter has been examined by the Learning Tribunal. The Learning Tribunal has confirmed that after examining all the transactions, your lordship, the Learning Tribunal has confirmed that it is not transfer, it is interstate sale, and against that also this case is pending before Central Appellate Tribunal.
That order of tribunal, my lord, has been stayed by the CST authority. That order has been stayed. And again, my lord, it's a different year again.
That's right. So which years are these?
My lord, these are the years immediately succeeding 1991, 9192, 1993,
No,
1994.
also 89-90.
8990. Yes, immediately succeeding years, my lords. We are before my lords for 86, 87, 87, 88, 88, 89.
The
These are
subsequent
the next 4 years.
next
Right.
4 years are pending years. And
So 2 years can be knocked out saying no reassessment possible.
as your lordship pleases,
Yes, yes.
because so as regards to your lordship, so far as that reassessment is concerned, your lordship. Your lordship, because why I'm submitting my respectful submission for your lordship is that since the agreement as well as the contract and as regards to the factual findings are pending, your lordship. So your lordship is pending here.
My lords, I'm not sure how we can do again the factual finding now at this point of time for 8990. Matters have to be same only.
No. In the subsequent years, your lordship, more than 30 pages
already there before CST Appellate Authority, they will do. But if my lords remand this to again do factual verification, my lord, that would be very difficult at this point of time. Whatever documents we have the same documents only, my lords. And CST Appellate Authority has seen that those documents and whatever observation they did.
Yeah, the only thing is they need to have sent it back to the tribunal.
Yes, my lord.
And the tribunal again took a different view.
And
they
they
didn't agree with you. It did not
they-
agree with you.
They again state that order, my lords.
I know. I'm just saying it's going back and forth there itself.
Yes,
There's
my
no
lord.
finality.
There has to be a conclusion. That's why, my lords. If my lords want, we can go in depth in the documents right now. Also, my lords, I have no problem with that. But these things, my lords, we are only there are all these judgment of Supreme Court what I submit with my lords. The only thing is they have divided the goods in two parts. One is standard goods, other is non-standard goods, tailor-made goods. So for standard goods, wherein the branches are maintaining regular stocks, etc., even if I may have firm orders from them, from my customers, etc., still the authorities and courts have taken the view that all that is going to a branch is not towards any earmark towards any buyer. What is going is to in bulk to the branch, and it's branch discretion to earmark and appropriate it to any contract they like. And my lords, in my own case, if again my lords see the last 3 pages of the paper book 2, during the period, my lords, my different branches have transferred stocks to different branches also. There is a requirement shortfall somewhere else. Category A customer wants it on priority. So my one of the BSO will transfer to some other branch. And there are 5 different plants, my lords. No one knows which plant will supply to which branch and which customer will ultimately get that. So at the time when movement is starting,
reopening this whole thing. He has placed all the documents. It's there in all these paper books.
Your Lordship,
He is pointing out at least 3 documents which say there's no concluded contract. And these are only standard, these are not non-standard items. These are standard items. See, if you place something before us from these documents, which shows the movement of goods took place pursuant to a concluded contract, then we can say, send everything back for re-verification. But if you're not able to show even a single document which actually shows that there was a concluded contract which then triggered the movement of goods, we need not reopen.
Your Lordship knows very well one occasion, Your Lordship, it will be out, Your Lordship.
No, this has been adjourned. This bench itself has adjourned it 2 or 3 times now.
It has been
So there's no question of further adjournment.
dismissed and restored, Your Lordship, after.
Us, not it. Let's do that. 86, 87, 88. No reassessment. And this 80 subsequent years. Because of
I'm only on the final.
We'll say that whatever we are deciding is confined to 88, 89. We'll note the fact that from 89, 90 onwards, the matter is already subject matter of those other proceedings. So we can't obviously decide that. And that will be decided on its own facts.
Your Lordship, but
And particularly since you are saying every year, every transaction has to be seen, that will hold good for those years. If there's any other transaction in those years which shows that there was a concluded contract, then that will be decided accordingly.
Your Lordship, here only the similarity is that scheme, that time bound.
No, scheme is similar, but the tribunal itself is saying that scheme being similar. Appellate tribunal says the scheme doesn't mean it's a concluded contract.
Yes, Your Lordship.
Correct.
Your Lordship, only the finding of the assessing officer on different transaction, only that shows that there is but no document is there. Absolutely,
No document.
Your Lordship is right.
All right. So 148 is 86, 87 and 149 is 87, 88, is it?
Yes, my lords.
All right. So let's put down TRV 148 of 2001 and TRV 149. 147 is which year?
86, 87, my lords. Sorry, 147. 147 is my lord, 88, 89. Last one.
All right. So TRV 148 of 2001 and 149 of 2001. These 2 revision petitions by the SSC Steel Authority of India Limited, bracket SAIL, are for 2 years, that is 1986-87 and 1987-88 respectively. Paragraph. These revision petitions have come before the court pursuant to an order dated 26 July 1993 of the Orissa Sales Tax Tribunal, Appellate Tribunal, bracket Tribunal, which referred two questions to this court. The following 2 questions to this court for adjudication. 1, whether in the facts and circumstances of the case, the reopening of the assessment under Rule 17, bracket 8 of the CST, bracket O, Rules 1967 for the years 1986-87 and 1987-88 is contrary to law and without jurisdiction, question mark. 2, whether in the facts and circumstances of the case, the tribunal was not justified in holding that transactions of dispatch of goods from Rourkela steel plant to different branches outside the state of Orissa, according to the demand registration scheme and time-bound supply scheme as interstate sales within the purview of Section 3, bracket small a of the Central Sales Tax Act, 1956, bracket CST Act, question mark. Paragraph. Initially, both these were registered as SJC cases and then subsequently converted into TREV cases 148 and 149 of 2001. Paragraph. Relevant to both these years, the issue, an additional issue that has arisen, concerns the jurisdiction of the assessing officer to reopen an assessment in terms of Rule 10 of the CST bracket O bracket rules. Full stop. This question was perhaps not in the purview of the issues that arose when the aforementioned reference was made by the tribunal, because the law in this regard was clarified in the judgment of the Supreme Court in Ashok Leyland Limited with State of Tamil Nadu, AIR 2004 SC 2836. Full stop. In the said judgment, which is by a bench of 3 honorable judges of the Supreme Court, a categorical view was taken that once an assessment order has been passed under Section 6 capital A bracket 2 of the CST Act, it could not be subject matter of reopening of the assessment under the State Act. Full stop. The larger bench of the Supreme Court in the above decision held observations to the contrary made in the earlier judgment in Ashok Leyland Limited versus Union of India 1997 2 SCR 224 to be incorrect. Full stop. It was held that there could be a reopening of assessment only where the order had been obtained, open quotation, by commission of fraud, collusion, misrepresentation, or suppression of material facts, or giving of or furnishing false particulars. Unquote. Paragraph. It is only thereafter that an amendment was made to the CSTO rules.
Not CST Act amendment was made.
Sorry?
CST Act amendment was made.
The amendment was made to the CST Act in 2010, right?
Yes, my lords. Finance Act 2010.
By 2010.
My lords, page number 6 of my compilation. Subsection 3 was inserted in section 6A.
Right. The amendment was made by insertion of subsection 3 to section 6 capital A of the CST Act with effect from 8th May 2010, giving the assessing officer the power of reassessment. Full stop. Paragraph. In the years with which the present petitions are concerned with, that is 1986-87 and 1987-88, there was no power of reassessment with the assessing officer. And therefore, the reassessment orders whereby the inter-branch transfers made by the petitioner SSC were treated as interstate sales, were beyond the jurisdiction of the assessing officer. The court therefore considers it necessary to formulate the further question of law relevant to the above issue, as it directly arises from the impugned orders, impugned reassessment orders in the present cases, colon, open quotation, whether on the facts and in the circumstances of the case, the assessing officer could have reopened the assessment under Rule 10 of the CST bracket O bracket rules, question mark, paragraph. The court considers it necessary to address the above question first as far as these two revision petitions are concerned, since it goes to the root of the matter. Paragraph. As already mentioned, in Ashok Leyland Limited versus State of Tamil Nadu, Supra, the Supreme Court disagreed with the earlier view expressed in Ashok Leyland Limited versus Union of India, Supra, and concluded in paras 113 and 114 is under. Stick A to A. Considering that the law itself was amended thereafter with effect from May 2010 by inserting section 6 cap A bracket 3 of the CST Act, it is obvious that during the time when the reassessment orders were passed in the present case, the assessing officer did not have the power of reassessment. Full stop. Consequently, the above question is required to be answered in the negative, that is in favor of the SSC and against the department. Full stop. In that view of the matter, the impugned reassessment orders of the assessing officer are hereby set aside, and the original assessment orders, which were interfered with by the tribunal, is restored to file. Full stop. It must be added here that in the original assessment orders, the assessing officer had accepted the case of the SSC that the inter-branch transfers were in fact not interstate sales. Full stop. Paragraph. In that view of the matter, these two revision petitions are disposed of accordingly. Then now you come to TR-EV 147 of 2001. The present revision petition by the SSC Steel Authority of India Limited, SAIL, arises from no paper book, nothing here. No, pertains to the year 1988-89. Full stop. The present revision petition was registered as a result of the reference made by the Orissa Sales Tax Tribunal, Sales Tax Appellate Tribunal, bracket Tribunal, by the order dated 26 July 1993, referring the following questions for adjudication. 1. Whether in the facts and circumstances of the case, the tribunal was justified in law in holding that goods manufactured by sale in its Rourkela steel plant and dispatched from the plant to different branches outside the state of Orissa under the time-bound supply scheme and the demand registration scheme be treated as transactions of interstate sales coming within the purview of Section 3 bracket A of the CST Act 1956. 2. Whether in the facts and circumstances of the case, the tribunal has ignored the fact of absence of any conceivable link with the customers and the dispatch of the goods to the branch, question mark. Paragraph. Initially, the above case was registered as SJC number 97 of 94 and subsequently re-registered as TRE 147 of 2001. Paragraph. At the outset, it must be noted that the central plank of the submission of learned counsel for sale was the judgment of the Supreme Court of India in Tata Engineering and Locomotive Company Limited versus the Assistant Commissioner of Commercial Taxes, AIR 1970 SC 1281, which dealt with more or less similar branch transfers, which, according to the sales tax authorities in Bihar, were single quotes interstate sales. Full stop. The time-bound supply scheme bracket TBSS and the demand registration scheme bracket DRS in the present case are admittedly more or less similar to the stock transfer authorization that formed the subject matter of the above decision. Full stop. Reference may be made to paras 10, 11, and 12 of the said judgment, which gives an idea of the kind of system that was followed in the above case, B2B. Paragraph. As far as the present cases are concerned, the case of the SSC is that it undertakes stock transfers to its branches located outside the state of Orissa. And that the goods are then offered for sale to customers in those respective states. Full stop. Sales tax is then collected at such place of sale as per the laws of that state and deposited with the said state. Full stop. Paragraph. emphasis was laid by counsel the petitioner on what he termed as single quotes standard goods, unquote, and open quotation non-standard goods, unquote. He submitted that in the present case for the year 1988-89, what was transferred to the branches were all single quotes standard goods, in respect of which there may have been a booking under the TBSS. Full stop. The court's attention was drawn to the form filled up which page was that? Here.
That's 96.
97, right. The pro forma of the registration form filled up by the customer, placing a demand for supply of iron and steel materials. Full stop. Clause 5 of the said form reads as under open quotation. It is noted that registration of the above demand will not be construed to mean any commitment on your part to supply materials. Full stop, unquote. Relying on the observations of the Supreme Court in Tata Engineering and Locomotive Company Limited, Supra, it was submitted that once the assessee discharged the initial burden of showing that the transaction was nothing but an inter-branch transfer, it was for the department to demonstrate that the movement of goods from Orissa to outside of Orissa was a result of a concluded contract arrived at between the petitioner and the ultimate customer. Full stop. According to counsel of the petitioner, in none of these transactions has the department been able to produce any material to show that there was a concluded contract with the customer pursuant to which the movement of goods took place from Orissa to outside of Orissa, to the branch outside Orissa. Full stop. It must be noted at this stage that in Tata Engineering and Locomotive Company Limited, Supra, the Supreme Court agreed with the dealer that the movement of the goods was not pursuant to any concluded contract. And therefore could not be termed as interstate sales. Full stop. Paragraph. Counsel Mr. Sunil Mishra, learned standing counsel for the department, on the other hand, submitted that for the immediate succeeding years, that is 1989, 90, 1990-91, 91-92, and 92-93, and 93-94. The matters had traveled up to the Central Sales Tax Appellate Authority, New Delhi, which remanded the matters to the tribunal by the order reported as Steel Authority of India Limited versus State of Orissa, 2010 30 VST 334 bracket CST AA-DEL bracket. He accordingly submitted that, no, full stop. He pointed out that even in Tata Engineering and Locomotive Company Limited, Supra, and several other decisions of the Supreme Court, it had been emphasized that there has to be a verification of single quotes each transaction, unquote, before concluding by the assessing authority, before concluding that the transaction did not amount to an interstate sale, but was only a branch transfer as contended by the SSC. Full stop. He submitted that inasmuch as similar transactions under the same scheme, that is TBSS, was already subject matter of the order of the Central Sales Tax Appellate Authority. And those matters had, and some of those matters had come to the tribunal come back to the tribunal, to be decided in favor of the department, and have again landed back in the Central Sales Tax Appellate Authority. The present matter should also be sent back to the tribunal for a fresh determination whether the transaction in question for 1988-89 amounted to interstate sales as contended by the department, or was merely interbranch transfers as contended by the SSC. Full stop. Paragraph. There can be no manner of doubt that an assessing authority is required to examine each transaction forming subject matter of the assessment proceedings to determine whether it amounts to an interbranch transfer as contended by the SSC or an interstate sale as contended by the department. Full stop. Therefore, the decision in any particular year, even involving the same SSC and the same scheme, need not necessarily form a precedent for a subsequent year, since the transactions in each subsequent year will have to anyway be examined on a case-by-case basis. Full stop. Therefore, there need not be any apprehension with the department that if the court for the present year, that is 1988-89, decides that the transactions in question do not amount to interstate sales, then in all subsequent years, ipso facto, without anything more, all the transactions for those years will also be termed only as branch transfers and not interstate sales. Full stop. Paragraph. The court also notes that in its order in Steel Authority of India Limited versus State of Orissa, Supra, the Central Sales Tax Appellate Authority did not agree with the department that the TBS scheme itself was in the nature of an offer of sale. Full stop. The relevant observations of the Central Sales Tax Appellate Tribunal in this regard read as under C to C. Paragraph. From the SSC's point of view, enough documents have been placed on record in support of its contention that all the transactions forming subject matter of the assessment proceedings for 1988-89 were in fact branch transfers and nothing more. Full stop. On the other hand, the department has not been able to point out even a single document which would raise a legitimate doubt that the transaction was in fact a concluded contract pursuant to which there was a movement of goods from the Rourkela steel plant in Orissa to its branch outside Orissa. Full stop. In other words, the department has, while the SSC has discharged its initial burden of showing that the transaction was only an inter-branch transfer, the department has been unable to discharge its burden of showing that, in fact, the transaction was not merely an inter-branch transfer, but was a movement of goods occasioned by a concluded contract. Stop. Consequently, this court is not persuaded that the matter pertaining to 1988-89 should again be sent to the tribunal for verification of each transaction to determine whether it is an interstate sale as contended by the department. Full stop. The court already notes that more than 35 years have already elapsed since we are nearly 35 years have elapsed since we are talking of the year 1988-89, and these proceedings cannot interminably carry on. Full stop. Paragraph. For the aforementioned reasons, the questions framed are answered in favor of the SSC and against the department. Full stop. The impugned order of the tribunal and the corresponding orders of the First Appellate Authority and the assessing officer are hereby set aside. Full stop. In other words, it is held that for the year 1988-89, the transactions in question were branch transfers not amounting to interstate sales. Full stop. It is clarified that this finding of the court for 1988-89 will not preclude the department from demonstrating, for any of the subsequent years, that the transactions forming subject matter of the assessment proceedings in those years do not amount to inter-branch transfers. Paragraph. The revision petition is accordingly disposed of.
Careful, Your Lordship. Obliged, my lords. Deeply obliged.
One.
Lordship, item 51, similar identical issue of law has been identified and it is posted on April 19th.
That chief sent that.
Which date?
That is WPC number 21375 of 2017. That has been posted to 19/4/23.
19th April.
19th April, right.
A list on 19th April 2023 along with WP civil number 17746 of 2012.
No, my lord. 21375.
Okay, 21317.
17.
Okay, 21375 of 2017. All right. Regular list.
Item number 52.
May I proceed? My lord, the order passed by the State Information Commission is under challenge, my lord. Here, my lord, rupees 25,000 has been imposed as penalty. In fact, I have no fault. I have supplied the information time, but I could not brought these facts to the notice of the Law and Commission because, my lord, I was not allowed leave by the CDMO because we had a jaundice epidemic in the area.
So, sent a written thing, sir.
My lord.
Would have sent a written note.
My lord.
Sent a written note, sir.
My lord.
And 25,000 is nothing.
Page 30, paragraph 6, Lordship, kindly see.
The order, that is the relevant portion of the order. 100 days delay, correct.
Delete 100 days.
It's correct. Correct. You see the challenge in the present petition is to an order dated 23rd November 2017 passed by the State Information Commissioner. You could have gone to the Chief Information Commissioner, no? Isn't there an appeal available to the Chief Information Commissioner?
No, appeal is
This is second appeal.
the second appeal.
All right.
Under that case.
Disposing of the second appeal filed by the present petitioner and maintaining. Second appeal filed by the informant seeker, that is opposite party number 3, correct? Opposite party number 4. And levying a penalty of rupees 25,000 on the present petitioner, who was at the relevant time the PIO cum DPMU in the office of the CDMO Kalandi, on the ground that there was a delay of 100 days in his furnishing the relevant information sought by opposite party number 4. Paragraph. Having perused the impugned order of the SIC, the court is not persuaded that any error has been committed in levying the penalty once it was found that there was a delay of more than 100 days in furnishing the information. Full stop. The reason put forth by the petitioner.
Paragraph 9 of my petition. Page 7.
That he was suffering from jaundice.
Well, I was not suffering from jaundice. Because of the jaundice epidemic, the CDMO didn't allow me to.
That because of the jaundice epidemic, the CDMO did not permit him to attend the hearing is not very convincing, as the information could have easily been supplied without having to personally attend the hearing. Full stop. Consequently, the reason no ground is made out for interference.
Paragraph 9, my lord. I have supplied information. I was not the PIO.
At the intervention of the
I was the PIO sent me to supply the information. Paragraph 9 or page 7 I have a glance.
100 days.
I received within 7 days. I supplied. 18.3 I was asked to supply information. On 27 I have supplied. Within 9 days.
He supplied
Page 9 of paragraph 9 of page 7.
He asked information on 9/2/2015. He supplied on 28/3/17. That is an intervention of the second appellate authority. That's why.
I am not the PIO, my lord. I have
Yes, he's the PIO.
Paragraph 9 of the my petition was
more than, I think, more than 100 days, 2 years. The limit is 25,000. That's the limited 25,000 has been penalty.
But the PIO concern, my lord, he didn't supply me, didn't search for this information from me. And he is the opposite party number 3, my lord, 3.
It is noted that the petitioner was working as a district program manager in the district program management unit under the National Health Mission in the office of the CDMO Kalandi, and working under the administrative control of the CDMO. Was asked to supply the information pursuant to the order passed in second appeal by the SIC. So the information had been sought way back in 2015, is it? When was it sought, sir?
9/2/2015, paragraph 6
sought
30.
on 9/2/2015. Full stop. The delay computed is the delay in supplying the information after the order passed by the SIC in that regard. Full stop. Consequently, the court is not persuaded to interfere. The petition is dismissed.
Supplementary list item 53.
Item 53, influxes lordship.
Dismissed as interruptions.
Item number 54.
None appears dismissed.
My lord, I am for the petitioner, my lord.
You already tell us.
My lord, I am for the petitioner, and I am approaching this honorable court in my writ petition in nature of PIL, my lord, to quash the that is work order in favor of that is annexure, my lord, 2, my lord. Your lordship may kindly have a glance on annexure 2. That is for construction of Gram Panchayat Bhavan in the village of that is Panchayat Karyalaya, that is in the village of Koranji Gunpur, Miller, amounting rupees 20 lakhs. Your lordship may kindly have a glance. It is very interesting, Lord, how fraud has been committed, Miller. Your lordship may kindly have a glance on the counter affidavit filed by Tahsildar, Miller. Your lordship may kindly have a glance on page 8, annexure A by 5. The counter affidavit filed by Tahsildar, Miller. This is the letter of collector for allotment of land for construction of Gram Panchayat Bhavan. Am I read, Miller?
Carry on, carry on.
That is number, Miller, that is number 2915 dated 10/7/2020. Miller. All Tahsildars of Bhadrak district identification and alienation of unobjectionable government land for construction of GP Bhavan building under CFC MG NREGA convergence regarding. Madam Sir, with reference to subject cited above, I am to say that GP Bhavan buildings are going to be taken up under CFC MG NREGA convergence in GP level, with a view to providing wage employment to reverse migrant under Garib Kalyan Rozgar Abhijan. In view of the above fact, I would therefore request you to identify unobjectionable government land in consultation with BDOs concerned for construction of GP Bhavan.
1 minute, sir. Just come to para 11. If your counter.
My counter bill.
1 minute, sir. We are asking the government counsel to read para 11 of his counter affidavit. If you do not mind, sir.
The governments made in paragraph 4.7 of the writ petition is incorrect, wholly misconceived, disputed, and denied hereby. It is humbly submitted that though there is 86.49 acre of government land in Jolamandua River Revenue Village, but most of the land are Gochar, Gordonda, Gramya Jungle, so and so, which are not leasable.
Which is as if this is the, in every other case, when it is pointed out there's some Gochar land, you say, no, we can apply, we've already applied for its conversion. Suddenly you're now standing on high principle and saying none of these lands will be touched.
No,
this is all, after all, government land.
Yes,
so you've straight away rejected 86 acres saying it's not leasable.
No, thereafter, my lords, on 21st of September 2021, an additional affidavit has been filed on behalf of OP number 4, which is the BDO, my lords. My lords may kindly take that affidavit. This was, my lords, filed by the Tahsildar. The BDO has filed another affidavit.
Where is that?
There's an affidavit on behalf of OP number 4.
This is also 17th September 21 only.
Yes, ma'am.
Tahsildar is saying.
Yes, ma'am. This is 21st of September 2021. May I just read, my lords, if my lords has that counter affidavit?
Yes.
Well, it's para 4, man. That it is humbly submitted. Whereas this is a additional Gram Panchayat office, my lords. That it is submitted that Jolamandua Gram Panchayat is an old Gram Panchayat under Bhandari Pokhari block of Bhadrak district consisting of 7 villages, so and so. Jolamandua Panchayat consists of 18 wards, which is situated on both sides of National Highway. that on one side of the national highway, there are 8 numbers of wards, but there is no suitable place for construction of additional Gram Panchayat.
Has this construction been over now?
Well, as of 2021, about 5.5 lakh rupees had been up to the lentil level.
Mr. Parida, this construction taking place on plot 254.
Milord, they have given my lord work order in favor of the Panchayat Executive Officer for construction of Panchayat Bhavan at one village, and another village the construction is going on, Milord. In another village, and the Sarpanch has entirely acquired 2 acres and on the name of Panchayat Bhavan, he has already acquired in an encroached 2 acres and 60 decibel, Milord. And your lordship may kindly, on my humble submission before your lordship is that your lordship may kindly appoint one commission, and he will examine whether that encroachment is going on or not, Milord.
No, what you want is one Panchayat building, correct?
Milord, and I on my rejoinder, I have already given the sketch map. Your lordship may kindly have a glance on page 12. Page 12 of my rejoinder, that is the sketch map in yellow color. In Jalamundua Gram Panchayat, there are 86 acre, 49 decibel of
So is this Panchayat building coming up in Jalamundua or somewhere else?
No, Melas, there is a Panchayat building in Jalamundua. This is an additional Panchayat building, which is, Melas, because therefore, Melas, I was reading, if I may complete that paragraph, Melas.
Milord, when there are sufficient amount of government lands and leasable lands available at Jalamundua, it is needless to construct that is the Panchayat Bhavan building at other border village, Milord.
Why? What's your problem, sir? What is your problem if they construct an additional building in some other village?
No, Milord, here there are enough lands, Milord.
No, that's for them to decide where they want to have an additional building. Why should you insist it should be only in this village?
Milord, another thing, Milord, I am just bringing your lordship's knowledge, Milord. Your lordship may kindly have that is the letter of collector I have shown your lordship, that is dated 10/7/2020. The collector has already wrote letter to all the tahsildars for allocation of land. Milord, your lordship may kindly have a glance on annexure 1, page 18, Milord. Before the letter of collector, they already, the revenue inspector and the tahsildar, they have already allotted lands, Milord. That is dated 36/2020. Collector has given the letter on 10/7/2020. Before that, the one sketch map has given, Milord. Your lordship may kindly have a glance on annexure 1, Milord. That is the sketch map given by revenue inspector, and simultaneously your lordship may kindly have a glance on the work order, Milord. Work order has been issued on dated 15/5 on the month of May 2020. Collector's order 10th July 2020. Milord, before that they have already decided and done everything. Before the letter of collector, they have decided and done everything.
What is your problem, sir? It's still not clear.
Milord, my problem is that, Milord, on behalf of the villagers and of the Panchayat peoples, Milord, the construction work be done at Jalamundua village, Milord.
Why?
Milord, because there are enough.
That way there is enough land, let's say in Delhi. You can't insist that because land is available here, you must have a building here. There are other villages in the Gram Panchayat.
Milord, the Gram Panchayat, because there are 86.49 decibel of land, Milord, and most of the lands are leasable lands, and it is adjacent to the road, Milord.
What is your problem, sir? They want to have an additional Gram Panchayat building in some other village forming part of the Gram Panchayat. What is your problem?
Milord, work order has given in one village. Construction is going on another village. That is illegal.
These are not matters for public interest. You see, the grievance of the present petitioners who are residents of village Jalamundua is that the additional Gram Panchayat building is being is not being constructed in Jalamundua itself, but in some other village. The plea is that there is sufficient land in Jalamundua for having a Panchayat Bhavan office, and therefore the construction work at Karanji Gunupur, a border village, of the additional Gram Panchayat Bhavan office should be stopped. Paragraph, merely because additional land is available in Jalamundua does not mean that there cannot be the additional building of the Gram Panchayat Bhavan in another village in the same Gram Panchayat. Stop. These are not matters for public interest intervention by the court. The petitioners.
Millard, it is a gochar land, Millard, grazable land, and that cannot be transferred, Millard.
All right.
That cannot be transferred.
All right.
Item 55.
May I please, Lordship? Let's say, may I kindly have a glance to the order dated 17/8/2022, order number 6.
Yes.
The London State Council was directed to file an affidavit.
As item, if I may, my lords. My lords, because there is an exchange of land, my lords, those plots, because the Smashan plot is where the construction has already progressed, my lords. Therefore, my lords, the RDC is the authority which has to finally alienate the land in favor of this particular construction. So therefore, my lords, the files are with the RDC office. I have got a sketch map, my lords, but that is not properly scaled. Therefore, my lords,
all 4-5 months of adjournment, sir.
No, the RDC has not taken a stand yet, my lords. I have got
same order will impose costs, and then everything will come in place.
Whereas I've got a sketch map in a memo.
Don't treat us like this, sir.
No,
we asked you to file an affidavit. Don't simply hand over scraps of paper. Sorry. You say despite adjournments granted on 28 June 2022, 17th August 2022, 27 September 2022, and 7 December 2022. The affidavit supposed to have been filed, placing on record the rough sketch map showing what areas proposed to be earmarked for this Pashan to compensate the loss of land on account of construction to Panchayat Bhavan, has not been filed. Paragraph. It is directed that if such affidavit is not filed on or before 1st March 2023, costs of ₹25,000 will be paid by the state to the High Court Bar Association Welfare Fund, and proof of payment of costs will be placed on record. Full stop. If no such affidavit is filed, who will remain present, sir? Panchayat Development Secretary. Where is it stuck, the file?
Sarpanch of the Panchayat, despite service of the notice, is not appearing.
The Tahsildar Dashratpur will file the affidavit. He's the
OP number 7.
No, where is the file stuck? You said the file is stuck.
This file is stuck with the Revenue Divisional Commissioner, OP number 3.
The Revenue Divisional Commissioner, bracket, OP number 3 will remain present in virtual mode. Copy of this order be sent forthwith to the Revenue Divisional Commissioner for compliance. This on
Central Division.
17th April.
This is Revenue Divisional Commissioner CD, Central Division.
Central Division.
Central.
Mr. Mohanty undertakes to inform the concerned officer himself. So don't tell next time you marked something else and he did not know.
No.
You yourself inform.
Yes, please.
All right.
Item 56.
Item 56, my lord. My lord, Mr. Saktidas is engaged in this case, my lord. So, OP number 7 has filed counter. DO filed counter. The government has, I think, filed counter.
Well, it's OP number 3 and 9, Millers have filed a counter on the 5th of January, Millers. There's been the Tahsildar Bahanga Tahsil.
Filed, sir, 5th January. Have you got a copy?
I've served a
Five,
copy.
it's opposite to 5 and 10. Yes, I got this. 5 and 10. 5 and 10.
523.
Counter affidavit is filed by opposite parties 3 and 9 on 5th January 2023. Rejoined to be filed for the next date. List on 11th May.
Item number 57.
On 21/9/2022, directed the OP number 3 to file affidavit to the factual position of the case. As yet, they have not filed the affidavit.
Lord, the status report has not been filed, but I want to bring it some material facts before your lordship, which will be helpful for adjudication. This matter is a private dispute between the petitioner and opposite party number 7. Admittedly, a civil suit is pending before the Civil Judge Senior Division First Court Cuttack. That is at page 43. The sister of the petitioner has filed a civil suit for the self-same relief. And petitioner has filed the PIL.
It is incorrect. It is
and that suit is pending.
Let them
in
file
the civil
affidavit.
court.
Let them file
And that
affidavit.
is there in the record, annexure for page 43 of the counter affidavit filed by.
That is not related to this land. This is a land of fund. And 26, that is said that collector in his order said that there is a 2-storied building. For that, your lordship directed the collector to file his factual position to that effect to an affidavit.
That in that order, everything has been elaborated. And add to it, there is a civil suit pending. And
no.
See, last time we had asked the collector
Yes, my
to
lord,
file a
that-
separate affidavit.
Call it affidavit.
He said the collector, last opportunity is granted to the collector to file the affidavit in terms of the order dated 21st September 2022 on or before 3rd April 2023. List on 6th April.
Item number 58.
Lord, in this matter, counter has not yet been served, my lord.
Well, it is ready. I'm solving live.
Date may be given for.
What have you challenged, sir? Refund.
My lord.
It's asking for refund of penalty.
Woko's notice has been served. He has replied to it.
No. Your counter, you've not served a copy of the counter on him.
It is ready from 2016,
All
my
right,
lord.
copy of the counter affidavit be served on counsel petitioner within 2 days. Rejoined for the next date. 64, I think. List on 5th July.
Item 59.
May it please your lordships. Here a counter is necessary, my lords. Counter is necessary. Lordship may kindly look to the order dated 29th of March 2016. I am challenging a circular which is totally unworkable and it violates Article 14. Read with Article 19(1)(g) of the Constitution of India, my lords. Whereas my export sale, total export sales has been rejected because of a circular issued by the state government in exercise of power conferred under subsection 5 to section 8. Lordship will kindly turn to page 38 of the assessment order. 39, I'm sorry.
All right, and reply be filed within 4 weeks. Rejoined for the next date. Interim order to continue. List on 17th August.
17th August, my lords. And a petitioner will become orphan, my lords.
No.
Assessment order, my lord.
Assessment order, I am challenging you have not read my prayer.
All right.
Item 60.
Obliged.
Item number 60.
60, my lord, this is regarding imposition of penalty under section 65(1)(a) of the OVAT Act, my lord. Similar matter was in yesterday's list, my lord, item 67, that has been posted to 24th of April.
All right. List on 24th April along with writ petition civil.
My lord, 27285 of 2017.
Of 2017. All right.
Item 61.
Oh. 61, my lord, covered that
period is actually, if you look at
Case of automobiles.
1/4/2013 to 39/2015.
All right. All right. All right. Yes, same also.
Item 62.
62, actually, I would like to request your lordship to pray for next week or any day.
My lord, it is also covered, my lord's order, my lord, that Sahu brothers, part period. They have challenged
Part period.
Yes, my lord.
Up to 15 it will be.
Well,
Yes,
that I'll just take, that is exactly I know. I'll just examine it and any day next week. Your lordship.
So why, sir? Let it be. The same order. All right. Same order. All right.
Your lordship, keeping in view that
No, same order. That he'll go back, he'll calculate the differential amount beyond that period.
is that different?
10-15 ପରଠୁ ଯେତିକି ହେଇଛି
Yeah. Sorry.
I think the period, if your lordship
March.
But this period is
Fourth amendment, my lord. This is relative to fourth amendment 42.
1/10/2015.
This is post 1/10/2015.
Yes,
my lord.
Oh, then may not be covered then.
That is
Then
that is
take
exactly
off.
the doubt.
All right.
Actually.
You say at the request of counsel, senior counsel, the petitioner, list on April 13th.
Right.
All right.
Interim order to continue.
Interim order to continue.
Item number 63.
Bhavani.
My lord, next is interest matter, entry tax interest matter.
2nd February.
2nd February.
All right. List on. Second.
Item 64.
My lord, similar order may be passed.
Item 65.
65 and 68 are not present.
Not present.
65 and 68.
This is not
68.
My lord. Not
Item 66.
Lord,
No,
66,
68.
Mr. Patnaik was earlier appearing, but after his demise.
Sorry,
my
which
lord,
one are you?
today I received-
No, sorry. 65 and 68. Sorry.
My lord, 66. Today I only
66.
received the brief, my lord. Mr. Patnaik was appearing earlier, but after his demise, brief has been given to me just today morning. So may I pray any day, lordships, next week or it's convenient to your lordships any day.
All right. At the request of the list on 22nd August. Right.
Lord, interim order, we have deposited 50%.
That's already there, sir.
Interim order to cut.
No, but that's already there, I think.
Yes.
It's subject to the outcome.
Submit.
Yeah, that's already there.
22nd August. Item 67.
67, my lord, in view of the interim order, final relief has been granted to the petitioner, my lord.
All right. Counsel petitioner states the petition has become infructuous. It's disposed of as such. All right.
Item 69.
Permitted to withdraw, my lord.
Dismissed as withdrawn.
Obliged.
Item number 70.
70, my lord, infructuous.
Infructuous dismissed.
Item 71.
71 also, my lord, become
Same.
infructuous.
Item number 72.
Memo taken on record. Dismissed as not pressed.
Item number 73.
Liberty may be granted to file appeal in the first matter, my lord. The
All right.
second matter is infructuous, my lord.
All right. Second, you say dismissal is infructuous. First, counsel petitioner seeks leave to withdraw the present appeal with liberty to file an appeal. Before the against the demand notice, if such appeal is filed not later than 3rd April, accompanied by an application for conditional delay, will be considered in accordance with law. Explaining the delay on account of the pendency of the present. Be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in view of the matter. Petition is disposed.
Obliged.
Item 74.
74, Lord, the petitioner is a bottling unit. Lordship would kindly see annexure 2, page 13, which is the subject matter of challenge here. he was, the 25,000 of grain-based ENA was being transported through permit, following all legal means. It was through a tanker. The tanker met with an accident, resulting loss of this ENA on account of
this superintendent's order is not appealable.
This, in fact, Annexure 2 is the order. I'll show section 91. If Lordship considered section 91, he should have considered this, Lordship. See, the rule 91, that says that the commissioner it shall be proved to the satisfaction of the commissioner that such deficiency has been caused by accident or unavoidable cause. The duty levied on such deficiency shall be refunded. But I say that it's on account of accident, that goes admitted fact. Police has reported, excise officers have reported, but the commissioner says that there is no joint inventory. On that ground only he has passed order, and there is proving means he has not given me an opportunity, man. So all that I can request your Lordship is let the commissioner give me an opportunity. I'll place all the materials before the commissioner, then let the commissioner pass an order. That's the requirement of law under section 91. I'll go back to the commissioner, let the commissioner give me an opportunity. All admitted facts are there, records are there. Kindly see, my lord, I can show the FIR also. My lord, at page 28, this is in Odia. The police says that on account of accident, the tanker capsized and loss caused, my lord. The ENA got damaged. Then the excise authorities also report that way.
Let it go back, sir.
My lord, he has given his defense, I think, the impugned order reveals.
Where is that?
Sri Manohar Jaiswal, MD, High Tech Bottling, Annexure 2. Has requested for exemption of the duty leviable on wastage of spirit as per provisions made in Rule 91 of the Odisha. Such exemption is admissible with the...
No hearing given, my lord. No opportunity given to produce documents.
He has given his defense, that was considered, and ultimately commissioner came to this conclusion that this is a huge amount of demand.
Lord, I need an opportunity of hearing. Proved means he must inquire, giving an opportunity of hearing to move. That's the requirement of law.
Rule 91 provides that should be given opportunity for filing of so cause, that he has given the so cause.
So cause doesn't say proved. Kindly see. Rule 91 provided. Of Odisha Excise Rules 2017. Subrule 2. If the report of the officer by whom a consignment of spirit transported or exported by land under the bond or duty free has been gugged and on arrival at its destination so that it is proved that wastage to a greater extent than that which is allowed under Subrule 1 has occurred, the distiller or warehouse keeper, as the case may be, on receipt of an intimation to the effect and from the side officer shall pay for to the duty of the highest rate for the time being in force on contrary spirit in any place through which the said consignment was passed, and so much of the deficiency as is in excess of the above allowances, provided that if it shall be proved to the satisfaction of the commissioner that such deficiency has caused by accident or other unavoidable cause, the duty levied on such deficiency shall be refunded, and in any case, commissioner decision shall be final.
All right.
So proved means I need, you must give considered all the documents. The documents have not been considered. He only said that the representation is there. I said, and commissioner said that I am liable to pay it. The reports have not been considered. Excise officer's report is there. It is damage on account of accident.
Police direct the commissioner to reconsider.
All right. The challenge the present petition is to an order dated 20th February 2018, passed by the Excise Deputy Commissioner (CD) Cuttack, requiring recovery of rupees 110,67336 from the petitioner on the ground of wastage of spirit. Full stop. According to the petitioner, it has a valid license for compounding, blending, and bottling of foreign liquor, IMFL, having its separate bottling unit. Full stop. They said that pursuant to a valid permit dated 8th May 2017. The petitioner imported 25,000 BL of grain ENA by a tanker from a company in Punjab and paid all the statutory dues. According to the petitioner, the tanker bringing the consignment was involved in a road accident, causing the death of the helper. The entire consignment was virtually wasted and damaged. Full stop. Information was given to the local police as well as the Superintendent of Excise, Sambalpur. Paragraph. The petitioner applied for exemption from duty in terms of Rule 91 bracket 2 of the Orissa Excise Rules 2017 OE rules bracket. But this application was rejected by the order dated 20th February 2018. And thereafter, the impugned demand was raised, could stop by issuing notice in the present petition.
Yes.
On 23rd March 2018, the impugned demand was stayed by this court. Could stop, that stay has continued since. Could stop. A counter affidavit has been filed by the opposite parties, stating in talia that it was not proved to the satisfaction of the Excise Commissioner that the shortage of the green ENA was caused by accident. Paragraph, Mr. P.K. Rathil, Learned Counsel for the petitioner, submits that no personal hearing was afforded to the petitioner during which he could have placed materials to show that there was an accident leading to the wastage of the spirit. Paragraph, it does appear from the impugned order that there was no personal hearing afforded to the petitioner. Full stop. Rule 91 bracket 2 of the OE rules reads as under. We produce the whole rule. Paragraph. The proviso to Rule 91 bracket 2 requires the person claiming exemption to single quotes prove to the satisfaction of the commissioner, unquote, that the deficiency has been caused by accident. Full stop. With this burden being placed on the petitioner, it was incumbent for the petitioner to be given an adequate opportunity to place all the materials available with the petitioner to discharge the above burden. Paragraph. In that view of the matter, the impugned order dated 20th February 2018 of the Deputy Commissioner and the consequential demand of the same date raised by the Superintendent of Excise hereby set aside. The matter is remanded to the Deputy Commissioner, bracket CD, bracket Cuttack.
My Lord, Commissioner, Excise Commissioner may be direct, not the Deputy Excise Commissioner.
The matter is remanded to the Excise Commissioner, Odisha Cuttack, to afford the petitioner a hearing on a date to be informed to the petitioner at least 10 days in advance. The Excise Commissioner will, after considering all the documents, materials placed by the petitioner, pass a fresh order. Not later than.
And after hearing the petitioner, otherwise.
That's right.
He's saying that again he will come that I have
not later than 1st May.
Again he will
2023.
I will not
hearing
and be communicated to the petitioner within a week thereafter.
I am sure Commissioner will do justice.
A copy of the order be sent to the Commissioner, Excise, forthwith for compliance.
Item 75.
But interim order is there. That
Till such time, no coercive steps will be taken.
So I'm appearing for the petitioner.
75, Lord, I enter appeals today. Lord, I need Lord 1 week time to, because today I'm hand over the brief. So.
All right. At the request of counsel for the department. List on 22nd August. There's an interim order.
Well, there's an interim order.
All right. Interim order to cut. All right.
So Lordship have fixed it to
22nd August.
No, Lordship, Lord, yeah, earlier, so.
No.
22nd August is a dangerous date for us.
Let's say at least April, not.
No, it's fine.
All right. Item 76.
76, Item 76, if you kindly look at order dated Order number 7, 20th September, my lord. 20th September, your lordship directed within 2 weeks they have to provide a list of allottees, 102 applicants. But if your lordship 3 days ago, they served me a copy. But an affidavit has been filed 3 days back. And I have to take instruction. In fact, lordship kind of visualize one thing. But they are in their residential house. They want to be displaced. They have got old persons, ailing persons, children, all those persons are there. But now they say only allotment, but as it appears from the affidavit. But they can reside there. They have to make construction. The rehabilitation center is not fit, my lord. If your lordship kindly visualize, I can bring your lordship notice that it is all dilapidated and declared unsafe.
Millard, I have filed affidavit, Millard.
Let them respond to that.
Yes, let me check up, Millard.
Because Millard, my humble prayer is that, Millard, my humble prayer is that mining is closer to the villages, Millard. Short date may be fixed, Millard, so that Millard.
No, you gave 3 days ago, actually.
Millard, short date may be fixed so that Millard.
Yes.
Millard, it is affect the mining, Millard, and we have allotted the plot in since 2019, Millard.
MCL has filed an affidavit.
Sir, we have all sacrificed.
Dated 12th January 2023. 20th January, is it? No, 12th.
12 January.
12th January 2023. To which senior counsel for the petitioner would like to respond. Full stop. The rejoinder to be filed before the next date. Interim order to continue. This on.
Interim order, there is no interim order.
There
is no interim order.
List on.
The short date may be fixed so that it is a national, it is affect the national courts.
23rd March.
Little bit February, so that it is affect the mining activities. So that.
Item 77.
In item 77, the GA department is the appellant challenging the order of the Honorable Single Judge who has revived a lease which was cancelled for violation of the lease condition and non-deposit of ID cost. And the land is situated in Bhubaneswar town, is a very costly land. In 1994, the lease was granted. He did not deposit the ID cost, which is a requisite, which is a required condition as per the lease deed. And the court has said that you deposit this with 6% with a normal interest after 24 years and it will be revived.
So last time you'd asked me served on HP Manti. Somebody is to appear for the other side, sir.
Other side, 77. SB Das. HB Das. Oh, Mr. Saktidhar Das.
Copy of the appeal paper book be served on. But it can't be a senior advocate, no. It has to be some.
Mr. HP Mohanty case.
That we have already last time said.
The Haripad Mohanty, I think his junior.
Copy the you say Mr. Mohanty learned AGA states that he will serve Dasti. A copy of the paper book on Mr. HP Mohanty. Advocate.
List on appeal memo. I'll solve. Yes.
List on 21st August. 21st August.
21st August.
78.
Yes. What's the delay?
It's here, it's a delay of 50 days. This case number 301 of 2017. Since the writ petition was of the year 2008, we mentioned that we could not establish contact with the petitioner for the purposes of filing an appeal pursuant to the dismissal of the writ petition.
Let's come to the merits.
Well, it's here, this is a proceeding arising out of Regulation 2 1956. That's the difficulty here is that the original recorded owners of the land, they moved the competent authority under the Regulation 2 for ejectment of the present petitioner from the suit land on the premises that permission was never taken. Now, Lord, what they failed to bring it to the notice of the competent authority was in the year 1989, this a sale involving the suit land was effected in favor of another scheduled tribe person. but that's admitted. That sale deed could not be produced before the learned single judge, so that could not be taken into account. But fact remains, he was never impleaded as a party, because restoration in respect of the suit land, or if at all, is to be made in favor of the original, in favor of the actual owner, who is since 89. These persons are no longer the owners, because they've sold the land. So in the absence of the actual owner, recorded owner since 89, this order itself is.
The appellant is not the original owner, is he?
The appellant is not the original owner.
Then?
But the appellant, the interest of the appellant is that there was a civil suit filed between the appellant and the original owner, the 89 purchaser, Millard. In that suit, the relief for declaration was sought for.
So anyway, you can't get it.
But I'll just come to your lordship's query, Millard. But this appellant filed a suit for declaration against the purchaser of 89. But that suit culminated into a compromise decree. So that part of the compromise decree was not considered by the learned courts below, on the ground that section 7E of the regulation 2 is a bar.
Correct.
Your lordship will kindly see section 7E of the regulation.
Must have set it out somewhere. You've not set out section 7E anywhere.
But 7E not exactly quoted anywhere, Millards. I can hand over a book for your lordship's perusal, Millards.
Ask me.
So it's what I humbly beg to submit to your lordship is that the 7E is a bar with respect to all such reliefs that can be granted by the authorities empowered under the regulation. It's specific to the bar is very specific and exclusive.
To any matter which any officer or other competent authority is empowered by this regulation to decide.
Yes, Milord. So here my suit, the appellant's suit against the purchaser was for declaration. So that relief.
Subject matter is the land.
Subject matter is the land, Milord.
Land belonging to a scheduled tribe.
If the land belongs to scheduled tribe person, any mode of transfer by way of decree, by way of sale deed, everything is hit under these particular regulations.
Towards my humble submission would be, Milords, that the original purchaser has not, in fact.
But how does it? Anyway, the land doesn't come to you.
But and the second limb of my humble submission is that this judgment of the Honorable Supreme Court in the case of Amarendra Pratap Singh, Milords, there the aspect of long-standing possession was discussed as to the person to be in unauthorized occupation was for a period of more than 30 years. So therefore, while the Honorable Supreme Court negatived the point regarding adverse possession, but there were certain guidelines which the Supreme Court has in fact directed the concerned authority to look into after remanding it. Odisha.
Yes. This is a case of Odisha.
Yes,
Mayurbhanj district case.
If your lordships will kindly see.
Possession is also barred.
It is barred. There's no doubt.
Adverse possession is
adverse
also
possession is barred. I'm not an adverse possession, Lords. I'll just take your lordship's kind notice to para 32 of that judgment, the last but one page, Lord.
Yes.
But certain directions were provided to the, if your lordship kindly sees, but point number 2, the trial court shall determine, after hearing the learned counsel for the parties and if necessary, by recording additional evidence, whether a decree for demolition of the construction made by the defendant respondent number 1 and specific restoration of possession to the plaintiff appellant is called for. In the alternative, the trial court shall determine if, in spite of the encroachment having been proved, a decree for the award of suitable compensation in lieu of demolition and restoration of possession would be a more appropriate relief.
No, but that's not the subject matter here. Here, nobody's going to be sending it back to a trial court at all.
No, but it's here.
This is a sub-collector's order which you challenged before the single judge.
Yes,
and sub-collector's order was under the regulation.
Yes.
Let's hear.
So there's no civil suit for it to be sent back to some trial court and all that.
No, but not the trial court. That's what I humbly beg to submit here is that here the petitioner is in possession since 1959. Well, that's admitted. Well, that's not disputed by any of the authorities. Now, it's since 59 he's in possession by constructing a dwelling house and he's residing there on Millards. That's only if an opportunity is given for the authorities subordinate, my lord, to find out a way to maybe quantify the compensation, because now, my lord, restoration in favor of the original purchaser is what these respondents would not be restored with the lands because they have sold it. There's a sale deed to that effect. I also have a copy of that sale deed. Let's be applied a certified copy of that sale deed in the year 2017, for which it could not be brought to the notice of the lower single judge.
That sale deed is attached.
I'll just hand over a copy to you.
Just because the buyer must be a scheduled tribe.
Yes, absolutely.
So that then again another scheduled tribe person will be put to jeopardy.
Yes.
If your lordship will grant any compensation or any interference, that then second purchaser will.
I'll just clarify
because this sale deed is valid.
He's the first purchaser.
ST and ST.
He's the first purchaser.
No, but the sub-collector was moved by Shri Gunakar Majhi.
Yes, please.
And Mahi Majhi. So Gunakar Majhi is definitely interested in getting the land back.
No, these persons would not get the land back. My humble submission would be that by virtue of this 89 sale in favor of Lakshmiram Majhi, he's a stranger to the family of the respondents.
No, Gunakar Majhi sold it to Lakshmiram Majhi.
Yes. He is a scheduled tribe. Maybe a stranger. He is a bona fide purchaser.
So if
there is no violation of
that
law.
Lakshmi, whatever.
Restoration in favor of these respondents is not feasible because they've already sold it. That's what my humble submission is.
That
they may have sold. The person who bought it from them,
yes,
he will go back and he'll see how to get it back.
There was the person who has bought it from them. He entered into a compromise with me.
So that's not valid. That's not a valid compromise. That's the whole point.
But
because you are a non-tribal, so how can he enter into a compromise with you?
My lord, this law is very strict. And any type of transaction without the permission is invalid. Even if civil court decrees are not accepted, adverse possession plea was not accepted.
So your vendor, if he's agreed that the property has gone to his vendor,
yes,
he will take appropriate proceedings, sir. You don't have to worry.
Against the second buyer.
Correct.
Yes.
Well, we'll observe that.
All right. Well, the challenge in the present appeal is to an order dated 22nd. Sorry, is to an order dated.
A copy of
7th April 2017, passed by the London Civil Judge, dismissing writ petition civil 13991 of 2008, filed by the present petition, present appellate. Paragraph. In the writ petition, the appellant had challenged orders dated 27 September 2003 of the sub-collector in regulation 3(2), case number 303/2002, and an order dated 22nd January 2008 of the additional district magistrate Bairumaj in regulation 2, appeal number 10 of 2003, whereby the appeal filed by the present appellant against the aforementioned order of the sub-collector, accepting the plea of Shri Gunakar Majhi and Mahi Majhi, under section 3(2) of regulation 2 of 1956 for voiding the sale transaction entered into by, what's your vendor's name?
My vendor's name is Dibira Majhi.
Dibira Majhi.
Dibira Majhi is in fact the same family as these respondents.
Dibira Majhi in favor of the present appellant. Paragraph. The sale in favor of the present appellant was obviously done without prior permission under regulation 2 of 1956. Stop. In the circumstances, any subsequent compromise in a civil suit between the appellant and his vendor could obviously not confer valid title on the present appellant. Full stop. It is this that has persuaded the learned single judge to observe in the impugned order that the bar under section 7 capital E of regulation 2 of 1956 to the court entertaining any suit involving properties belonging to a scheduled tribe was total, and that any decree passed by the civil court would be a nullity. Paragraph, the court is unable to find any error having committed by the learned single judge in this regard. Paragraph, counsel of the appellant then submitted that the vendor of the present appellant was not made a party in the proceedings before the sub-collector and subsequently the ADM. And therefore, even if the decree of the civil court was declared to be a nullity, the property could not revert to the
respondent,
but only to the petitioner's vendor, the appellant's vendor.
But he's the purchaser. He's not my vendor. He's a purchaser. He's the
no, but you bought it from him, right?
But the purchaser got it from the respondents.
I got it from him.
I got it from the original recorded tenant in 59. That is Dibira Maji. These respondents, I'll just clarify, my lords, subject to your lordship. These respondents are of the same family as Dibira Maji.
All right.
These respondents sold it to this Lakshmiram Maji in 89. He's a stranger to the family.
So they are the successors of his vendors.
So you bought it from Lakshmiram Maji?
No one, my lords. Lakshmiram Maji is the last purchaser. And Lakshmiram Maji is not made a party to the proceedings.
Exactly.
That is what my humble son.
So far as what he is saying that he's a stranger to the family, that has got no meaning, because a stranger can purchase subject to the condition that permission is granted or he belongs to the scheduled tribe person.
Because I was only clarifying that there is the last purchaser is Lakshmiram Maji.
All right.
That's all.
Counsel for the appellant contends that inasmuch as the last purchaser was Lakshmiram Maji, he should have been made a party to the proceedings, and the property cannot revert to Dibira Maji.
To these respondents.
To the respondents who are the successors in interest of Dibira Maji,
yes,
the vendor of the present appellant. Paragraph. If Lakshmiram Maji has any grievance in this regard, it is for him to seek appropriate remedies against the respondents. Full stop. In any event, the property cannot revert to the present appellant. Full stop. Consequently, the court finds no reason to interfere. The appeal is dismissed.
Correct.
This all should be sent. This, that.
There is one Passover, right?
Item 79.
79, these batch of writ appeals involve cancellation of caste certificates. But as it appears, my lord, the the state level scrutiny committee, who's been made a party to the writ appeals, the AD is not back from them. My lords, if your lordship directs, I'll take fresh notice on the state level scrutiny committee.
I'll appear on behalf of the state level scrutiny committee. The last order, there's an additional affidavit which was filed. We had undertaken to file a reply to it. I've got the paravise comments. I'll file it within a week's time.
All right. Mr. Mahanti states that he'll be appearing for the state level scrutiny committee as well. He also states that the reply to the affidavit filed by
appellants,
the appellants will be filed before the next date. List on 17th August.
That's
18th
October.
Supplementary list passed on matter item 33.
Can I request for a shorter date? That's because these are cancellation of caste certificate matters. So if I succeed, I'll revert to the posts I was holding prior to the cancellation.
It's all right. It's all right. Yes.
Item number 33.
In item number 33, I have filed a short date check for convenience of your lordship. Amen. My lord, the petition was dismissed on the ground of delay and also on the ground that I should have preferred an appeal. My lord, after exhausting all the remedies, I was before this honorable court. And way back in 1886, the additional district magistrate was pleased to direct the Tahsildar to settle the land in my favor. The Tahsildar didn't take any step, for which I have to run to this honorable court. And this honorable court once again direct me to approach the Tahsildar. I went once again to the Tahsildar, and the Tahsildar dismissed it, although he doesn't have the jurisdiction to dismiss the same in view of the settlement made by the order passed in 1986. The Lordship may kindly turn to.
But that order of the Tahsildar you challenged in 2012, that writ petition was dismissed because you did not remove the defects.
My
So
lord,
can you keep going again and again with so many petitions?
My lord, that is there, my lord, because due to non-removal of defect, it was dismissed for non-compliance of the peremptory order. But thereafter, I filed a petition to recall that order.
That again 3 years later.
No, my lord, not 3 years later, because your lordship may kindly see. The petition was dismissed on 15th, and immediately on 18th, I have filed a miscase.
Immediately? In 2018, you filed it,
my lord. That is
3
true,
years
my lord.
later, not immediately.
My lord, after filing, when the matter was listed, it was missed. Somehow it was missed, and for which I filed memo. And after filing of the memos, when the matter would not be listed, I verified and found that this order has been passed. But for that, my lord, may I submit?
Your lordship may see the impugned order. What has happened? He should have filed appeal before the sub-collector.
No,
that is just a minute. I'm saying something in your favor. Don't worry. So he should have filed appeal before the sub-collector. Honorable single judge said that without filing appeal, you straight come to the High Court. So if your lordship thinks it just and proper, she may be permitted to file appeal and along with the limitation petition and that
against the Tahsildar's order.
Against the Tahsildar order. And if that will be condoned and the matter will afresh.
He is really very fair.
No, my lord, because she has not been given
hearing on merits.
Hearing on merits. That is why I am saying that let her try her luck before the sub-collector.
One more lease of life you get.
Obliged, my lord.
The grievance of the present appellate, whose writ petition civil 189006/2019 has been dismissed by the learned single judge by the order dated 27 January 2022 on the ground of delay, is that the challenge to the order dated 27 November 2010 of the Tahsildar
Section 12.
Appeal is to be filed under section 12 of the OPL Act.
The father of appellant number 2 to vacate the scheduled land has never been examined on merits. Stop. Paragraph, as rightly pointed out, instead of the order being challenged in the writ petition, the appellants should have approached the sub-collector.
Under section 12 of the OPL Act 1970.
To challenge the order of the Tahsildar under.
Before the sub-collector. Which
under
district?
Section 12 of the OPL Act.
Jaipur.
Sub-collector Jaipur.
In that view of the matter, while setting aside the impugned order dated 27 January 2022 of the learned single judge, the court permits the petitioner to file an appeal against the order dated 27 November 2010 before the sub-collectors. Jashpur, is it?
Jaipur.
All right.
District Korapur.
If such appeal is filed not later than 3rd April, accompanied with an application for condonation of delay explaining the delay on account of the pendency of the aforementioned proceedings, in this court. They said it will be considered in accordance with law by the sub-collector. The court
No
clarifies it
observation
as-
regarding merit.
Uh,
Lordship, no.
It will be considered on merits by the sub-collector. So, the sub-collector, the petitioner will appear for this purpose before the sub-collector. Jaipur. On
Chapter scoring.
10th April. The sub-collector is requested to dispose of the appeal within a period of 6 months thereafter. Till such time, status quo shall be maintained by the petitioner.
Obliged,
By
deeply
the-
This
obliged.
court is not expressing any
The
opinion.
court clarifies it is not expressed in
You're
these
deeply
matters.
obliged, Lordship's copy.
You have to be obliged to. All right. Yes. All right. We will take it up correctly.
2 more.
All right.